Tēnā koutou katoa. Welcome back. Resumed hearings on the proposed Timaru District Plan, hearing stream E. We begin this morning with submissions from Rangitata Diversion Race Management Limited. I think we've got Corey Lipinski, Legal Counsel, online. Morena, can you hear us okay? We can't hear you. Still no sound. Do you want to try maybe just going out and coming back in again and just see if that corrects any bugs? Thank you. No sound your end. Can you check your microphone or... Yeah. Yeah, we don't have that. Mr. Lipinski, we can't hear you. We're just going to stand you down for a moment and we'll hear from one other submitter, and just if you can maybe check your technology, or can we have a phone connection, not for us particularly, but with the tech support? Mr. Lipinski, no? No. You might need to go and get a little bit of IT help at your end. Oh, no, we've got you now.
Oh, you've got me now? Okay, fantastic.
Excellent.
Sorry about that. I was panicking a little bit because it was working on my end. I was about to call our IT tech man here.
Oh, good. Look, we're in your hands. Thank you.
Good. Tēnā koutou katoa. Council's name is Corey Lipinski, and I'm here representing Rangitata Diversion Race Management Limited, or RDRML for short. I've pre-filed some legal submissions earlier this month, and I just want to confirm that the panel's had the opportunity to read those. Fantastic, thank you. Mr. McCormick, Tony McCormick, who's also the CEO of Rangitata Diversion Race Management Limited, had filed some evidence for hearing D, and I'd referred to those briefly in my legal submissions, and I just want to confirm if the panel's also had the opportunity to read or reread his evidence. Fantastic, thank you.
I think some of us have reread it, but we definitely all read it at the time of hearing D, so
Yep,
You-
I recognise all your faces from that hearing as well. So I'll go through, and just as a brief outline, and these submissions I'm just going to address. I won't read the submissions, seeing as you've read them, but I'll draw your attention to some key points. So the key issues I'm going to cover today are Timaru District Councils, which are referred to as council throughout, their jurisdiction to create planning provisions in the bed of a river. Regardless of that, whether or not it's appropriate for the council to impose rules in the bed of a river. Ms. Liz White's amendments that she's proposed in her Section 42A report to the specific provisions in the SASM. And lastly, some relief that RDR-ML proposes. So RDR-ML is particularly interested in the sites and significance of Māori provisions, and in particular the Waitokoa overlay, which covers its infrastructure in the Rangitata River, which is a rockwear that goes from one side to the other. With respect to the jurisdictional argument, in my submission, Council does not have the jurisdiction to create planning provisions in the bed of the river, given that this is a function that falls wholly within the jurisdiction of the Canterbury Regional Council. Ms. Vela, the legal counsel for Council, in her response in hearing D, disagreed with this position that we'd made, but we maintain our position that there's no clear distinction between the activity being regulated by the Council's provisions and the Canterbury Regional Council provisions, and that to regulate this maintenance of rockwears in the bed of a river better falls within the Canterbury Regional Council provisions, falls within the function of Canterbury Regional Council. Since the definition of land and land covered by water could apply to the bed of a river, there's some overlap between the functions in sections 9 and 13 of the Resource Management Act. So we have to look at sections 30 and 31. And in my submission, there's not clear how the proposed rules in Council's provisions regulate something that's different from the regional council's rules. And for these reasons, I'm submitting that there's no clear jurisdiction for Council to create rules in respect of the Rangitata River. Moving on to my second point is based on the merits. And I'm going to say even if Council, in my submission, even if Council's proposed planning provisions in respect of riverbeds are lawful, I question whether or not it's appropriate to apply any rules to the riverbed. So there's a couple of arguments I'll raise here, and the first one is based on a geographical location where the entire Rangitata River falls within the district or within the region of the Canterbury Regional Council, but only half of it falls within the Timaru District Council. And if you look at the planning maps, the boundary goes right down the centre of the river, so the planning provisions relating to the SASM overlays only apply halfway down, and the other side of the river applies to the Ashburton Regional Council. And given that the Rangitata River sits wholly within the Canterbury region and only partially within Timaru, it's my submission that it is preferable to leave any rules relating to the management of earthworks in this riverbed to the Canterbury Regional Council. The second argument under this merits-based position is that it'll create confusion and unnecessarily duplication between both Canterbury Regional Council and Timaru District Council rules. So if both councils have provisions that relate to the earthworks of the riverbed, there's nothing in there to differentiate the types of effects that are being managed between the two. So you're, in some sense, in some degree, you're regulating the same activity twice. In RDR's case, our client has an existing resource consent from Canterbury Regional Council, which is attached as an annexure to my legal submissions for this hearing and to Mr. McCormack's evidence for the previous hearing as well. This resource consent regulates and allows RDR-ML to maintain and reconstruct its existing rockwear. And the current provisions of the proposed Timaru District Plan is going to either potentially create an obligation for RDR-ML to either obtain a new resource consent for certain activities or at least prove existing use rights. So there's an overlap there between, and not just solely for our client's case, but for other submitters and possibly other people who are doing work in riverbeds, some confusion about what rules and what obligations need to be fulfilled and what consents might need to be obtained. Moving on to Ms. Liz White's Section 42A report, she's made a few recommendations which I'll acknowledge RDR's position on. So she's recommended that the Waitokoa overlay is effectively merged into a different provision, and the Waitokoa overlay being the one that our client's concerned with. On top of that, she also recommends inclusion of a particular exception for a permitted activity for earthworks, which is earthworks authorised by the Canterbury Regional Council for the maintenance of existing rock weirs and river works to the same level and extent as occurring as at 1st of January 2000. That would be a permitted activity so long as other requirements are met. And lastly, she's made some amendments to the accidental discovery protocol to no longer require that a form needs to be submitted in advance, but just general compliance needs to be adhered to. So Rangitata Diversion Race Management Limited generally supports the first two proposed changes by Ms. White. Firstly, that the overlay is incorporated into the first set of rules, and that exemption for maintenance of existing rock weirs is incorporated in there. Whilst that third change relating to the accidental discovery protocol goes some way of addressing the concerns RDR has about that protocol, in my submission it is still not appropriate to apply this protocol to the bed of any river in respect of the maintenance, and I'll go through my reasoning now. So the accidental discovery protocol, when you read it, contemplates that if any potential archaeological remains are found, that the site would be secured, and it uses the term in brackets taped off, which in my submission is not appropriate for the bed of a river. There's health and safety issues with someone having to tape it off. It might not even be physically possible depending on the flow at the time or depending on where it's located for it to be taped off. The river itself is a dynamic environment, so any archaeological remains that are found, and if work is paused and the Heritage New Zealand is contacted, any remains are likely to be washed away before the Heritage New Zealand is able to get there. Furthermore, and in particular to our client's case, and as you'll read in Mr. McCormack's evidence, when they conduct maintenance or repair of the rock where they're using existing rocks and existing gravel, and they reinstate those back up into the weir. So if any archaeological remains were going to be in that material, it would have been founded a long time ago, seeing as RDR's been carrying on this work or this activity since about the mid-1900s. Moving on to the relief, which I'll touch on the relief that RDR wishes to have in respect of this accidental protocol in here. So in descending order of priority, RDR seeks the following relief, that the SASM overlays are removed from the bed of the Rangitata River, so they're moved back, and so they sit on the edge of the riverbed. Secondly, that the SASM provisions are amended to provide that with respect to their application in any river bed, that they're for information only and no rules apply to any activities. Thirdly, that a specific rule is included in the SASM provisions to say that the maintenance or repair of any rockwear is a permitted activity, and I've outlined in my legal submissions what that would look like. And lastly, that the amendments suggested by Ms. White in her Section 42A report are adopted, but that certain amendments are made to the accidental discovery protocol to say that with respect to any earthworks associated with the maintenance, repair or replacement of rockways in the riverbed, the requirement to comply with the accidental discovery protocol does not apply. And I've suggested some wording in my legal submissions as well. So in conclusion, firstly, I submit that Council lacks the jurisdiction to impose planning provisions in the bed of any river, and therefore this should be left to the Canterbury Regional Council. Notwithstanding the jurisdictional argument, I submit that it's inappropriate for the SESM provisions and rules to apply to the bed of the river in the Timaru district, as it creates a double up with regional council's function, and that can lead to any confusion about what applicants need to be applying for and which rules might apply to their activity. And those are my submissions, and I'd like to offer up to the panel to ask any questions that they might have.
Thank you for that. I'll see if the panel have questions.
Thank you.
Morena, one question
Morena.
for you, please, in relation to your submissions around the relief you're seeking in terms of being exempted from the accidental discovery protocol.
Yes.
In terms of how those permitted activity conditions work in SASM R1, I note that Per 2 states that except where an archaeological authority has been obtained, the earthworks are undertaken in accordance with accidental discovery protocol.
Yep.
So have you contemplated the that if you were to explore some kind of authority for any works that were required, then that would then negate the need to for the earthworks to be undertaken in accordance with that ADP?
Yep. I
Could
agree
you
with
just talk me through that?
Yeah, sure thing. That would probably be a question, unfortunately, that would be better put to Mr. McCormack, but unfortunately he was unable to attend today. But I do agree that if our client were inclined to explore getting a authority, then that would negate the need to provide any amendments to that provision.
Is that something you could check with him for
Yes,
us
of course.
and have him respond to us in writing? I think that would
Yes,
be
of
useful
course.
to understand.
Yes, I'll follow up and return to the panel.
Great. Thank you.
Thank you.
Sorry, folks. Kia ora koutou. Kia ora koe. So
Yeah.
my question is trying to understand, I understand that it's a dynamic environment in the river, and I wanted to know, well, in practice, what would happen if you were to find some archaeology, or in particular some ko iwi, some human remains, like what in practice would actually happen?
I've had a brief discussion with Mr. McCormack about this, and I understand that there are some procedures in place, but again, that would be something I would need to run by him to get the exact detail of what sort of procedures he had, what the actual procedure that they have in place and the specific steps that they run through, and then I'd be able to return to the panel on that as well.
That would be helpful then to be able to compare it to the accidental discovery protocol.
Yes, of course.
And my other question was your relief, so paragraph 20, and specifically relief C, which is your third preferred relief, excluding jurisdictional issues, and that's to have a rule that permits maintenance repair of existing rock weirs as a permitted to permit it. My question would be, would you want that to be for all existing rock weirs or those that have authorised with a regional council permit?
Specifically for our client, we would want it to be existing rock weirs that have previous permits or consents from regional council, because our client's rock weir, they have a consent from council. So I can't speak to anyone else, but we would probably put in there, like you said, something along the lines of existing rock weirs that have consent from regional council or from district council.
Okay, thank you.
Thank you.
Yes. How does the Ashburton District Plan deal with the weir in the Rangitata River?
I wouldn't be able to tell you off the top of my head, sorry. I'd have to look at the rules again.
Okay, thank you.
Thank you.
Mr. Lipinski, Were you involved in the gap analysis work that was done following hearing D with Ms White and I think Mr Hole from Rooney Group? Did you participate
Yes.
in that?
Yes.
So that work resulted in a table that Ms White included in her response to minute 19, and it identified rules in the regional plan so that we could get an understanding of what the overlap or gap was between proposed regulation under the Timaru District Plan and what was covered in the regional plan. Do you recall?
Yes.
That work?
Not the specifics, but I recall the table and some of the gaps.
Yeah, I just wondered whether, is it useful for you to perhaps reflect on that table, but this time with the SASM in mind, and just provide some comment to the panel on where the gap lies. I hear what you say in terms of your submission around the different functions of the regional council and the district council, but it would be useful to understand whether the regional council rule framework enables consideration of the cultural values that are protected by or identified in the particular SASM overlay in the district plan. Would
Yes,
you be
of
able
course.
to
I can look at that.
do that? It might be worth talking to Ms White about that and just get some as to where that gap lies.
Yes, of course. I can return to the panel on that and speak to Ms White.
Okay, that's my only point, but thank you very much for your presentation this morning.
Good. Thank you for your time.
Thank you. Welcome, Ms Hamilton. We'll hand over to you.
Thank you, Madam Chair. Kia ora, panel. I'm sorry for the wad of paper that you've just been given, but just to make sure you've got what you need in front of you, we've prepared a proposed itinerary for the sites that you wish to visit, and that includes not only the submitters that I'm acting for, but the other two, just to help the panel. And then there are some supplementary legal submissions which I've put together to try and draw on and pick up on some of the points that have come through the evidence and legal submissions of other parties, but also some of the conversations yesterday between the 42A officers and legal counsel for TDC and the panel. And there are a couple of additional points that I'll work through as well. And then we've got summaries of the evidence of John Evans, Reese Hart and Gerald Hargraves. The other witnesses have actually got a summary in their evidence themselves, so they will talk to those in due course. I might just start with the itinerary just to give you a bit of a flavour for what we've suggested. And essentially it is quite a trip Commissioner Scott will be able to play tour guide. She'll be more than familiar with these areas, I hope. Our suggestion is that you may wish to start going north from here towards Temuka and to shoot off to at Hurapa Street and where the Aorai Whenua marae is, because that will give you some context to where the marae is before moving up and visiting the farms on the northern side of the Ōpahi River, coming back over, visiting the farms on the southern side of the Ōpahi River, and then coming through to the Perior catchment, which is the last two, the Jameson and the Evans properties. A number of the properties, having talked to the witnesses yesterday, the SASM sites and the wider sort of farming activities can actually be seen from the road, and actually that gives you a much better sort of contextual view. So we've suggested for the most part that might actually be better than actually going on site. The EJAPS rock art sites are very difficult to access by foot, and we are conscious of the health and safety concerns around that. So having talked to Mr Goslin, it may be that they can take you to the top of the bluff, if you like, and then you'll get a bit of an overview of at least where those rock art sites are in proximity to farming activities. So that's our general approach. We've attempted to give you some directions as to roads and things and some maps, and we've also included in there the SASM overlay from the planning maps to per farm, so that it's all in one place for you. You don't have to be switching between documents. So hopefully that's helpful. The only thing I would suggest is I haven't spoken to Ms Swartz, but I understand that she is appearing before you maybe later today, so it might be worth just checking with her that she's comfortable. I will send this to her via email, but it's just probably just checking in with her that what we're proposing is suitable and things like that. I think that's probably it. We can provide any more information if there's anything that you need, and things like that, through the hearings administrator.
Thank you. We'll have a read through that, and if we've got any questions, we'll come back to you. But thank you.
Wonderful. So I will move to the supplementary legal submissions, and as I said, really this is just to pick up on a few bits and pieces that have come through the evidence legal submissions that were filed after we filed our legal submissions, and to pick up on some and address some of those additional issues that came through today. So I will talk to them because some of this will have come through in our legal submissions that we filed on the 30th of January. As you'll be aware, the submitters own and operate farming businesses on properties located variously at levels: Waitohi, Kakahu, Raincliffe, Pleasant Point, Cave, Hazelburn, Rangitata Gorge and Orari. Most of those properties have one or more sites and areas of significance to Maori on them, and we've included in this document and Schedule A just a summary of those SASMs per property for the hearing panel's assistance. As detailed in the legal submissions previously filed, the submitters acknowledge the cultural importance of sites and areas of cultural significance on their properties and the need for those sites and areas to be protected from the effects of land use activities, and genuinely view themselves as custodians of those sites and areas. And in their role as custodians, the submitters and those that have come before them in terms of having owned and farmed those properties have sought in good faith to gain knowledge and understanding of the historical and cultural context in the sites and areas, and to protect them. The approach they've adopted in the protection of those sites and areas and managing their farming operations near them has been acknowledged through recent consenting processes. The submitter's submission and further submissions on the proposed plan relate to the SASM chapter of the proposed plan and the associated planning overlays. Specifically, the submissions address the submitter's concern with respect to the process adopted by Timaru District Council in terms of determining the boundaries of the SASM planning overlays and developing the rule framework for land use and subdivision within those. It also includes the implications of the PDP, the proposed planning framework for SASM for their present farming activities and future land use options, and the consequential impacts on their farming businesses, including future saleability of property. The panel's role in balancing the interests of all stakeholders whilst ensuring the proposed plan and its SASM provisions, including the overlays, satisfy the minimum statutory requirements for district plan provisions, and I should add there, including the Section 6E RMA obligations, is a complex exercise. The supplementary submissions that follow seek to address the key concerns of the submitters in a comprehensive way so as to assist the panel in carrying out that exercise. So the following matters are addressed. First of all, the process concerns and the submitter's preferred relief, alternative relief, which is around the review of SASM overlays and revisions to the SASM chapter, and some concluding comments. In terms of the process concerns, on behalf of the submitters, we wish to commend Mr Hackart on the approach he has taken since his appointment as Timaru District Council's district plan review, and that's around his approach and better understanding and identifying options for addressing submitter concerns. The work he's undertaking alongside Ms White, and I would also note there, and AECL, has resulted in the suite of revisions to the proposed SASM provisions as notified, as set out in Ms White's Section 42A report. Those revisions are generally supported by the submitters, subject to some matters that I'll address shortly. However, the revisions recommended by Ms White do not remedy the submitters' fundamental concerns with the process adopted by Timaru District Council in developing the planning overlays and the SASM provisions. The submitters genuinely feel let down by the TDC's sole reliance on the advice from Aoraki Environmental Consultancy and its cultural consultants to inform the development of the proposed planning framework for SASM, and by implication its disregard of the submitter's knowledge and understanding of SASM, which has been built over many years and generations of ownership of their properties and through recent resource consent application processes, and its failure to recognise the benefits of early engagement with the owners of land on which the SASM have been identified in the plan development process, particularly the identification of the values of individual SASM and potential threats to such values. Their specific concerns include that the map boundaries of the SASM for rock art sites include buffer areas that extend well beyond the sites and areas that have been assessed through recent resource consenting processes as having cultural values requiring protection or ongoing management. For example, Mr Evans' regional land use consent for farming imposes a 1 to 1.5 metre fence setback from rock art and a 15 metre setback for irrigation. I might just note at that point, the interesting thing with the ECAN regional land use consent for farming process is that the matters of discretion for the restricted discretionary activity in relation to those activities is broader than just the rock art site management areas. It actually requires a much wider cultural values assessment of the property that is subject to the consent application. And in terms of other sites, the map boundaries do not reflect the physical characteristics or limitations of the protected site or area. For example, SASM 17, which is related to the Awarua stream, extends a considerable distance inland beyond the springs and wetlands noted in the site type and values in Schedule 6C Waitapu areas of the proposed plan where the stream is ephemeral. The other specific concern is there's an absence of evidential justification for the map boundaries of the proposed SASM in terms of the values of each SASM that are protected and the buffer areas required to manage the effects of land use activities that pose a threat to those values, and consequently the rules in the proposed plan SASM chapter. I'd note there too that there's obviously another issue that popped up yesterday during the hearing, which was around the rock art site SASMs and whether the categorisation of the wider spatial area is actually correct and whether it's not in fact two SASM types. So that's obviously something that the panel will have to turn its mind to as well. In terms of the further specific concerns, Kati Huarapa and its agency AECL will benefit financially from the consultation and cultural assessments expected for applications for resource consent required by the rules of the SASM chapter when those rules were informed by Kati Huarapa's advice to TDC. The issue around costs is also a concern in the sense of the regional consenting farming land use processes that have already been, that a number of the farmers that in the South Canterbury area will have already been through, and as I noted before, that the Regional Council requires a broader cultural assessment of the values of significance on the wider property, which have informed consent conditions which have been related solely, in the case of Mr Evans, to rock art sites and the effects of farming land use activities on rock art sites. So essentially having to go through another consultation process when those values have already been identified and recommendations provided would, in terms of efficiency in section 32, be problematic. And finally, the lack of consideration
Ms.
given...
Hamilton, I just wondered, are we going to be provided a copy of the farm management plans for any of your
We can provide that.
witnesses?
We can provide that. Mr Fraser has provided parts of it in his evidence, which relate to, I think, the rock. And he can talk to what he has got, but we can provide that if that's helpful to the panel.
Thank you.
I'd just note that not all of them will have farming land use consents and FEPs because of the nature of their farming activity. But for those that do have them, we can certainly provide that.
I've just flagged that the particular matter I'm interested to know as to what is the land use that they relate to.
Yes, yep, we can certainly provide that for you. So the second one was the need for district planning restrictions on land use activities within SASM when various other to protect cultural values from such activities already exist, including under the Canterbury Land and Water Plan and the Heritage New Zealand Act. It is acknowledged that the RMA does not impose mandatory consultation obligations on territorial authorities to consult with landowners affected by proposed planning restrictions before the public notification of a district plan. However, early engagement with landowners as part of district plan development processes is not uncommon, and in this case would have, in my submission, complemented the work carried out by the cultural advisors in relation to the sites and areas identified as potentially significant and enable mapping areas to be corrected prior to public notification. It is also acknowledged that the panel can only make a determination on the proposals before it, not hypothetical scenarios. That said, the submitter's concerns emphasise the need for the SASM overlay to be based on evidence of the cultural values of each site and or area, what land use activities could threaten those values, and what is reasonably needed in terms of planning restrictions to protect such values. For all these reasons and those further addressed in the evidence filed on behalf of the submitter's preference is that TDC start again, that is, withdraw the PDP's SASM provisions, including overlays, and commence a new statutory planning process, which would involve engagement and consultation with all stakeholders, including landowners. And I think I would add in there, in light of the discussion yesterday, the Rock Art Trust, identifying and assessing each site area of significance and their values that require protection through district plan provisions, and the land area around those sites and areas required to manage the effects of land use activities that could pose a threat to the sites and areas. And finally, the development of new SASM overlays and plan provisions, including objectives, policies and rules, informed by the items noted at A and B and the outcome of cultural assessments and recommendations in recent consenting processes. The submitters did not expressly seek this outcome in their submissions, however other submissions provide scope for this outcome. Submitters acknowledge that this approach may not be favoured by the panel, particularly in light of the TDC's obligations in terms of Section 6E, 6F, 6G, 7A and 8 of the RMA, and for the proposed plan to give effect to the National Planning Standards, which includes a mandatory requirement that district plans include a SESM chapter. Turning now to the alternative relief. If the panel does not favour the start again option, the submitters would support Ms White's revisions to the SESM chapter subject to, in terms of the SESM overlay, the extent of mapped area of Waihi Tapu sites that relate to rock art be reduced to include the extent of the specific rock art sites and a 10-metre buffer area around those sites. In terms of the rules, the inclusion of a permitted activity rule or advice note to give greater certainty around the continuation of existing use rights. And in terms of Schedule 6, further specificity of the values of each SESM to be protected and potentially the activity that pose a threat to those values, and any adjustments required to reflect the appropriate classification of those SESMs in light of that discussion between Mr Henry and the panel yesterday, and redefining the SESM overlays to reflect that reclassification and or any new evidence produced on the profile of effects of land use activities on SESM. And I'll just touch on those various matters now. So in terms of the buffer areas for rock art site SESM, the request for a 10-metre buffer area around SESM that are related to rock art sites, and that's SESM 8 and 9, is simply to reflect the advice from cultural consultants and recent resource consenting processes to the spatial extent of areas around these sites that are necessary to protect cultural values. There's no evidence that a buffer area around those sites of either 250 metres per Ms White's recommendation or 300 metres per Ms White's understanding of the approach that was adopted in mapping the SESM and the proposed plan as notified is necessary in order to protect those types of sites and their values. In terms of existing use rights, the legal submissions filed on behalf of Fenley Farms and A. Rooney referred to the Environment Court's decision in Advanced Properties, which confirmed that from a district planning perspective it is not satisfactory to leave present activities dependent on Section 10 existing use rights for future activities. And in that case, the court favoured the option of a schedule of existing commercial activities for the zone under appeal and to provide that they were able to continue indefinitely. Counsel for TDC also cites this decision in her legal submissions but favours the use of a district-wide advice note or similar to reflect that nothing in the plan affects Section 10 of the RMA. The submitters support either option, although it is submitted that a permitted activity rule and associated schedule would provide greater certainty for both plan users and those implementing and enforcing the plan, and by implication result in a more efficient outcome in terms of Section 32(1)(b)(2) of the RMA. Should the panel be minded to adopt this approach, the submitters would welcome the opportunity to work with TDC uses and the associated rule. If the panel's preference is an advice...
Sorry, Hamilton, just on that existing use rights, how do you deal with the requirement in the regional plan for farming activities to have farm management plans? If we're talking existing use rights in a district planning context, but if farms are required to have farm management plan, should the rules, if we were to go down that route, should the rules only permit that which is subject to a farm management plan?
Either that, or you could have an advice note that actually alludes to the regional plan rules. Often you've got that sort of advice note that says this, if you've got potentially a Heritage New Zealand type Act requirement, there's often an advice note that just alludes plan users to the fact that what you're looking at here might not be the same in other regulations. So that would be one's option. Or, as you say, it could be that you build the regional consenting requirement in the FEP into the rule, but I guess the risk with that is we know that the legislation is driving a different type of freshwater plan. So the terminology and the consenting requirements might shift over time. So that might actually lead you back to an advice note that just refers to regional planning requirements. Yeah. I guess it's no different to the types of advice notes within the district plan as proposed that defer to, say things like, you might tick this box in this chapter, but we're referring you to the, the earthworks chapter or whatever. And you may need a consent under that. At paragraph 20 of the panel's preference as an advice note is submitted that the following suggestion proffered in the evidence of Rachel Thomas and Greg Anderson on behalf of Fed Farmers may suffice, and you will have read that particular note, which is set out in their evidence. In terms of Schedule 6 and the SASM overlays, unlike outstanding natural landscapes and outstanding natural features of the proposed plan, there is no report detailing the values of the sites and areas of cultural significance listed in 6 other than in a generic sense, and/or principal threats from land use activities and subdivision, and consequently the buffer areas required around each site to manage those threats. I should acknowledge the case law that has been referred to in other legal submissions around the fact that it is for mana whenua to identify those sites, so we don't have a problem with that. It's just a very difficult space, I think, here, where if you're comparing other types of planned development processes, particularly around those significant natural areas, you will always have some sort of foundation evidence about what is on the ground, which then justifies the overlay for those areas. In terms of the Section 32 tests of efficiency and effectiveness, the desirability of identifying the exact location of SASM as well as their extents where possible provides a higher degree of certainty for plan users, and that has been acknowledged elsewhere. In other district plans, the spatial extent of SASM has been verified, and where verification has not been possible, where a site or area has a silent file status, the map SASM includes the extent of the site area and a buffer area informed by evidence as to what is required to protect that site and or manage the adverse effects of land use activities on it. Rules then address what activities can be done on SASM or within their vicinity. We acknowledge the difficulty faced by the panel in determining what is the most appropriate approach in terms of the RMA, in the absence of evidence justifying the spatial extent of the SASM listed in Schedule 6. However, in our submission, such evidence is required to enable the panel to be satisfied that the spatial extent of the listed SASM is suitable, and that's not superior, and the least restrictive method for achieving the objectives of the SASM chapter, and required to implement the policies of the SASM chapter. It is respectfully submitted that for these reasons and the shortcomings of the process adopted by TDC in the SASM mapping exercise already addressed, that Schedule 6 and the SASM overlays do require review. And I just note there that yesterday Mr Henry had alluded to the fact that there are some missing SASM, and presumably a planning process will need to be initiated to update the district plan to include those, and that could be a possible opportunity for a wider review of those, the overlays and the categorisation of them. The submitters consider that such a review could occur either as part of the current statutory planning process or through a variation to the proposed plan. If we're looking at a variation, in my submission, the panel could recommend that TDC initiate that planning process, comprising a review of the boundaries of each SASM listed in Schedule 6 following pre-notification engagement consultation with landowners and the full suite of stakeholders, I would note, including the Rock Art Trust, for example, and informed by evidence gathered, including from landowners, as to the values of each SASM and the principal threats. And the inclusion of a policy directive in the SASM chapter that signals TDC's intention to undertake that review. Or the panel could request, as part of the current statutory planning process, that TDC produce evidence to substantiate the boundaries of each SASM listed in Schedule 6, that is confirmation of the values of each SASM and the principal threats from land use activities to those values. And on the basis of that evidence, confirm each SASM has been categorised correctly, redefine the boundaries of each SASM as required, and provide more specificity in Schedule 6 regarding the values of each SASM requiring protection and the threats to such values. If the review is to occur outside the present statutory planning process, our submission is that it would be appropriate for a policy to be included in the SASM chapter signalling the intention of TDC to promote a variation plan or plan change for that purpose. We submit that this could be achieved through amendments to SASM P1 as follows, and I've suggested some alternative wording there. And I would just note it's not uncommon for this type of policy to be included in plans where there is actually intended to be a separate planning process to for whatever reason. So in conclusion, it's respectfully submitted that Ms White's recommended revisions to the SASM chapter, subject to the additional changes addressed in these legal submissions, are required to ensure the rules in the SASM chapter implement the objectives and consequently the policies of that chapter, and in particular policy SASM P5 as required by section 75(1)(c) of the RMA, are appropriate within the context of section 32 and in terms of efficiency and effectiveness, represent suitable, not superior, and the least restrictive regime for managing the activities that potentially threaten the values of SASM, provide greater certainty to plan users and those implementing and enforcing the plan's SASM provisions, and do not unnecessarily duplicate other rules in the proposed plan and the other existing regulatory process for the protection of SASM. And that concludes my submission, so I'm happy to answer any questions from the panel.
Morena, Ms Hamilton, thank you very much for your legal submissions this morning. If I could please take you to paragraph 16 of your supplementary legal subs. So I understand that in your legal subs there's insubstantial evidence around the proposed buffer area, and you're submitting that a 10-metre buffer area would be suitable. Can you please point us to or explain the evidential basis you have for that metric of 10 metres and how that might then align with or give effect to the regional framework of regulations that would apply?
So the primary evidential basis for that is the recent resource consenting process that Mr Evans has been through for his farming land use activity, and in his evidence he talks about that process. Consultation was undertaken with ACL and the process and the recommendations around what cultural values were on the site was related only to the rock art sites, and as part of that a condition of the consent was a 1 to 1.5 metre buffer or setback from the actual site itself for the farming land use activities. So and I guess the other element is Mr Fraser talks about his farming land use consent, slightly different approach, but his setback, and he will be able to confirm he's fenced off these sites, and they were given the Rock Arts Trust themselves were very impressed with how he was managing things in terms of that protection as well. So that's the evidence really. It's more about what has come through the regional consenting and then providing them a bit more buffer, if you like, than what's been suggested there.
Thank you. It's useful to see how the implementation of the regional framework played out in an actual resource consenting process. It's been really useful. Thank you. In terms of the evidential basis for a substantial alteration to a district planning proposal, is it sufficient to rely on a site-specific consenting process as evidence in terms of how that might apply or play out across a multitude of sites within a district?
It would depend on what site you're talking about and what the actual values of that site are and how the land use activities could affect it. And I think this is a bit of a difficulty now we've got with Ms Wyatt's revisions, because they have been reduced down to very specific activities that actually are, I think, and from what I can tell, quite, what would I say, more disruptive in terms of ground disturbance and maybe dust, that actually a framework that identified a site and then had a specific buffer that was reflective of the land use effects of that particular activity on the site would have probably been a more appropriate approach. But I understand the point that it's been an evolving process, and District Council have landed on one approach and now they're trying to manage how that plays out now. But it's difficult because there will be sites too. If in the sense of a rock art site, you could have differing values in terms of the level of significance of particular sites, which may or may not be as significant as others. So there is a bit of needing to have some sort of assessment undertaken to be able to identify what the significance of the site is and how the activity would affect it. Yeah. Does that answer? Sorry, that was a bit of a long way of...
Yes, no, thank you. That was useful, thank you. I had a question based on your legal submissions, not the supplementary ones we have in front of us today. You've made a comparison in Appendix A of your legal submissions around other district plan approaches in support of the concern that the proposed approach isn't suitable and perhaps is too onerous. And we had a discussion yesterday and in terms of I think the word we arrived at was that there's a significant concentration of rock art within this district, which is perhaps unique of remaining rock art, which could be quite unique in a New Zealand-wide context, and perhaps that in the North Island their planning regimes may be quite different because of that actual difference in the presence and remaining instances of rock art. Is it appropriate to look at those different approaches in the North Island as you've presented?
The reason I actually did put those in those legal submissions is if you go back to the original AECL report, it actually has a table in it which refers to those district plans and some others. And so that's where that came from. And I think that was them, in terms of the report authors, probably saying, okay, these are the different frameworks that you could adopt. Here's some examples. Here are our recommendations based on that. So that is the basis for referring to them.
Thank you for that's useful to know the background to why you've focused on those. And you've also mentioned the Dunedin City Council approach. And I was looking at that approach, and I am familiar with that approach. So are you suggesting that as part of your relief, that if the schedule was more specific and articulated some of the values and the principal threats in a similar way to the Dunedin District Council plan, that would allay some of the concerns around the specificity of what applies.
Yeah, and the method, the thinking around that is that we've got a plan that allows for, there's an expectation that there will be a consultation process, and it's really to ensure that the framework for that consultation and the matters that TDC would be considering as part of a consenting process are quite clear. And I think in light of where we got to yesterday with the rock art sites maybe having in part another category there, before that the thinking was that we really need to understand what are those other values, because we know the rock art site and that's got specific values, but this wider area, how does that fit into the mix, particularly in light of the consenting processes where the wider cultural values assessment has only focused on rock art sites. So it's more about giving the plan users and those implementing and enforcing the plan more certainty, really. And when you look at the Dunedin City Plan, it is quite specific, and I appreciate that in the Timaru district there are quite a lot of SASM sites, and that's quite a task to go through, but it does give the flavour of what you could do and which would provide more certainty. And I think they've also gone so far as to refer to the actual threats. I would think that normally through the Section 32 process you would have an analysis of those threats, and then from there what the recommendations are in terms of buffer areas and activities that need to be controlled, which I accept Ms White's point that actually that's the rules, that is in the rules, but they've obviously taken the view that it's better to have it very clear in the schedule.
Thank you. Thanks for talking me through that. No questions.
Kia ora koutou. I do have a few questions, but first of all, I'm just getting a little bit stuck on the submitter list and how that compares to the Schedule 11 submitter list of the original submission.
Yeah.
And relying on Mr Evans' evidence when he's not on either submitter list. Our thinking was that because he's been through a very recent consenting process, he could be a witness for... A witness, okay, got it. Witness for the group. So that's okay. Really... And I think actually that's played out well, because it gives another set of evidence for the panel to understand how that farming land use and other forestry consent applications have actually been dealt with. Yeah. Okay, thank you for clarifying that. And my other question just on the affected properties, this table that's in the supplementary is really helpful, because obviously I was looking for the properties and applying the overlays, but what it does point out is that we're actually talking about more than just rock art.
Yes, yeah.
Yes.
So the one that we've got a list of members of that group. The ones that are here today are the ones that wanted to give evidence. So much of that is focused around the rock art. Right. And I guess the legal submissions are more directing around the SASM overlays and other categories as well, in terms of general principles. So that's essentially the approach that we've taken. Great, yeah. Thank you. Thank you for clarifying that. That makes sense. And just following on from your discussion that you were just having with Commissioner Day, you were discussing, well, why the wider area than just the 10 metres or the rock art site itself. And yesterday we heard evidence from the reporting officer and cultural advisor that essentially those rock art sites are like a signpost that mana whenua would travel along travelling routes and stop overnight and then use that as a signpost to say, hey, there's things here, and it's more indicative of the wider social values that attach to that whenua. Yes. And so I just wanted to know whether you've taken that cultural advice, or your clients have taken that cultural advice, or are aware of
that approach?
Totally understand it. I think it goes to that categorisation issue that came up yesterday in the context of that discussion, is whether or not it is actually the site that's being mapped is actually all wahitapu, or whether part of it is actually something, one of the other categories, because of the type of association, if that makes sense.
Yes.
The occupation is something different to the values that you've got with a rock art site. So it was just a question as to maybe that needs to be reviewed to make sure you've got the right categorisation of the sites. I think it possibly only affects those rock art sites, which is the 8 and 9.
Okay, that's really helpful. Yeah. Thank you. We also heard that from a cultural advisor position, that the setting of a buffer is really just to have a trigger to enable mana whenua who also consider themselves as guardians in Kaitiaki to be involved in the discussion around how to protect the rock art sites. So that will enable both groups of guardians to come together and protect. So what would be an appropriate trigger to incorporate mana whenua guardian advice?
Well, the consultation is the only approach that you, and I guess I think Ms White has referred to the fact that it's up to the applicant whether or not they go and do that, but in terms of being able to get a resource consent application granted, that is going to have to be part of that consenting process. The other element is an outside of the plan process where there's a relationship established between mana whenua and the landowners that endures, over time to ensure that they're communicating about the sites that are on their properties.
And we can only look to what's inside of this process.
Yes, that's right, that's right, yeah.
My other question was, and I only have two more, it was in relation to paragraph 21 of your supplementary, and you actually spoke a little bit outside of the words that are written here, and my understanding of what you said was there was an agreement that it's for mana whenua to identify the sites that are important to them.
There's case law that says it is the role of mana whenua to identify the sites. That's only them that can do that. Right. Okay. So there's an acceptance that you're bound, as a panel, you're bound by that approach, as are the submissions that we're making to you. So.
Okay, so how would that then relate to the relief that's sought if we were to have a review that in 24A1 it talks about Timaru District Council initiating a separate statutory process where landowners are involved in identifying the values. Are the values separate to the sites, and are the values that we're talking about cultural values, and who would actually flesh out cultural values?
So I think in terms of a planning process, if you could do it well, is that mana whenua would identify the site, the location of the site. There'd be input from other entities, including like the rock art, the landowners who have got obviously a body of history and knowledge that they can add to the mix, and then that would inform, together with evidence around what the effects of particular land uses are on those particular sites, that informs how the plan plays out in terms of rules and policies and things like that. So it's really making sure that all of the evidence that's available is in the mix from the get-go to inform the planning process.
So I think it might just be in my head when I see the word values and I associate it to cultural values, but I think what you're saying to me, and I just want to confirm that I understand it, identification and description of those values are for mana whenua, but how it's going to be managed and appropriately managed takes into account everybody's knowledge of that whenua. Would
Well,
that be
I
fair
think,
to say?
I think the evidence from the group is that they have sought advice over the years from various different groups.
Right.
So they know quite a bit about those sites, and so that history or that history piece kind of feeds into the mix as well. It is for mana whenua because it is to achieve that Section 6E, it has to be that they are the people to identify the sites, but there's no reason why the body of knowledge from others can feed into essentially how that's managed or the location of the site or whatever. So
Okay.
there may be some that they may think are there, but when they go and see that actually we're not too concerned about it, or it's sort of more that ground truth thing and feeding in all bits of information that are available to ensure that planning framework is robust, I guess.
Okay,
Yeah.
thank you. And my last question is it's the same question that I had to the reporting officer yesterday, because I'm still really struggling with Rule 1 and trying to understand how it actually works. And I really what we're talking about here is earthworks and mining and forestry. But if I just focus on my understanding of the earthworks rule and the rock art sites, so my read of it is it falls into subcategory 3 because it's subclause 3 because it's wahi tapu, which makes it permitted where you have an accidental discovery protocol, and that's the only restriction because it's not in one of those per 2 sites, which is says in 1A, 4A or 4C. So when it comes to earthworks and wahi tapu, outside of 1A, 4A and 4C, so including rock art, it's quite permissive. Probably
That's having a
more
wee-
permissive than the earthworks rules.
So my reading of that is that you would need to, under that 3, so the wahi tapu rule is that you'd have to achieve both of the permitted activity conditions, so per 1 and per 2.
Per 2 just says for within, says in 1A, 4A and 4C. And my understanding is this doesn't actually apply. So it's really it's more permissive to have earthworks in a SESM than it is in an earthworks rule.
Yes, I think you're right, actually having had a look at that. Yes, and the struck out wording would have been a lot more stronger in terms of being able to flick that into a consenting process.
And it's not to say that the struck out will be accepted. So,
That's right,
Yeah,
that's exactly right. So it may be the panel's decision to revert back to the notified version. Yeah.
Yeah, great. Thank you. They are all the questions from me. Thank you.
Ms Hamilton, I just had a question for you in relation to section 32. And in your submissions, you address us on the effectiveness and efficiency of rules. And I just wanted to receive some comment from you in relation to the particular part of section 32, subsection 2. So in terms of an assessment under subsection 1B2, which relates to an assessment of the efficiency and effectiveness of the provisions, it refers to assess, so 2C, assess the risk of acting or not acting if there is uncertain or insufficient information about the subject matter of the provisions. And a strong part of your submissions is that the panel just doesn't have in front of it sufficient evidence to justify the regulatory provisions. I'm interested to know your thoughts in terms of the relative risk of not identifying these SASMs, notwithstanding that we may find that we don't have all of the information that we need.
Yes, absolutely agree. And there was actually an admission on my part, but I agree that if you haven't got that evidence, then there is that ability under that provision to make the determination that you the risk of not acting is high in terms of protecting those sites. And I'm just thinking about Mr. Henry's comments yesterday about this being the first first opportunity to be able to get these sorted in a district planning sense. I guess my submission in relation to that is there's obviously some quite significant issues with, and it's evolving through this hearing process, of the way in which the notified plan has defined those boundaries in the overlays and also the categorisation. So a review is obviously going to be needed. So that is, for me, that in my submission, the process to do that is through variation or plan change. But I accept that the panel has the ability to make that call and say we're just going to have to go with having a chapter in here. It might not be quite right, but in terms of that provision, that requires us to actually have something there to protect these sites.
And then the focus really is on the rules themselves, and as
That's right.
it may be that, in fact, when an evaluation is undertaken about the impact on the rules, notwithstanding the overlays, that it's actually not, it is on the side of a light touch at this point in the process rather than a heavier hand and regulatory response.
You may, bearing in mind receiving all the information that you have, and there's a lot there, that's where you land, and I accept that. Yeah.
Thank you. Yeah. The other question I just had, you talked about it would be more useful perhaps if the plan provided greater specificity around sites or values and the potential threats to those, respecting, of course, matters that may be subject to silent files or are particularly culturally sensitive. The AEC, the report that sort of preceded the Section 32 analysis, I think you've referred to it previously, it's available on the council website and sits with the Section 2 evaluations. That provides quite a detailed assessment and identification of particular sites or the particular overlays and the threat analysis. Would you consider that information would support that greater specificity in the plan, or are you envisaging that there needs to be far more detail available in the plan?
I'd need to go back and have a look and see because I have looked at that, but not for some time. It may be that it does. I guess where I was heading to was looking at the Dunedin City Council and the approach there in terms of the values to be protected was more site-specific. I think the issue arises particularly in relation to those rock art sites and that broader area that is sought to be covered. But that may be dealt with if part of that overlay is actually meant to be a different category in terms of what it's actually protecting.
Okay. All right, I'll leave that there and look forward to hearing your evidence from your witness.
Sorry, Ross. Off you go. So we'll start with Mr. Hart.
Good morning, everyone. Thank you for coming along and hearing our submissions, and thank you to everyone involved, particularly Georgina and Lucy, and our group. Today, in my submission, I want to cover the process, the effects of the process, and some solutions. It's no secret that our group has become very disillusioned with this process. The main bugbear is the process seems to have been hijacked by John Henry of AECL when he made an approach to the planning department.
Mr Hart, actually, I'll direct this to Ms Hamilton. Look, if at all possible, it's not appropriate in our view that such language is used to describe a process that was put in place by the council. The panel doesn't accept at all that the process was hijacked, and I take from your legal submissions that you don't actually take any particular issue around the legality of the process that the council adopted to put in place this plan. The report that is on the table was prepared by AEC Limited, and we would prefer if it is referred to in that way. Thank you.
Right, point taken. The fact is that the Timaru District Council, for all other aspects of this plan, ran a consultation process and people could participate. We did not get the opportunity for this. And I think if you value democracy at all, it's about letting people have their say. We're all going to have different points of view, but at least if we get the chance to express those points of view, we have some ownership of the process. And I think the benefits go the other way as well. The panel and the council can get a consensus of opinion, and when they finally make up their minds, that gives them a mandate to go forward and put the regulations in place. One of the reasons why we were denied this opportunity was because the sites have a spiritual aspect to them. They're important to iwi from a spiritual point of view, and this we accept. But just remember, we've been on these sites for 118 to 150 years, and we have a strong connection to the land and to these particular sites. And dare I say it, we have a spiritual connection as well. So I don't think you can put any one group ahead of the other simply because of this. The other thing that concerns us is the planning buffer overlays were kept a secret from us until the plan was notified. And the planning department was instructed that there be no ground truthing. Now this is important because we've just been talking for some time about the plans and how they're really not up to scratch. And it is no wonder when they weren't ground truthed. So they're desktop plans. I suppose our concerns is that when people are trying to keep something from you, they're generally doing it for a very good reason. Now, perhaps they don't trust us. I don't know what the reason was, but I read where they were worried about vandalism of the sites. I would just say to you, there's no doubt sites were damaged, probably a long time ago, 60 or 70 years ago, but I would pretty well guarantee they weren't damaged by farmers. People painted over them, they wrote their names over them. Archaeologists actually cut some of the drawings out and took them away to museums. That was not the work of farmers. So we have been treated as the guilty parties here, environmental criminals, cultural criminals. It's certainly not the case. We have done our best to protect these sites in our own time, using our own money. So the process as we see it is clearly endorsed by the Timaru District Council. Don't get me wrong, iwi needed to be in the room at all times. It's very important to them and it's very important to us, but we needed to be able to participate as well. Now, when I look at, am I allowed to mention John Henry's name or do I have to talk about AECL? But in reading some of his quotations, he said he is not relying on the goodwill of landowners who have shown an interest in protecting these sites to date. Now, I just ask you whether this process is going, because you need to ask yourselves, well, when the dust is settled from this process, regardless of what the outcome is, who's going to look after these sites? You know, we think that we have been treated as collateral damage, and I suppose one of the effects of this is that we've gone from valuing these sites, they're priceless cultural assets. We've been proud to have them on our properties. We now see them as a liability. And in fact, we don't want to have anything to do with them. We would prefer them to be off our properties. They're more trouble than they're worth. So when you look at this, is this the way to protect these sites? I mean, there would be better ways of doing it. How about, considering we're not hard people to deal with, what would have been wrong with iwi approaching us and saying, look, we appreciate you've looked after these sites for 150 years. Is there anything we can do to help? We would have been overjoyed with that approach. We would have welcomed it with open arms. But I can tell you the approach that's being attempted at the moment is probably going to have the reverse effect. The other thing that concerns us, I've read Liz White's report. I think all 126 pages. You put a lot of work into it, Liz, and we appreciate some of the changes that you have made. But I would say to you and the planning department, I think you have to be very careful in relying on folklore, the stories that have been passed down from generation to generation.
Mr Hart, we're here to hear your views about the district plan. We've read what you've had to say. This is not an opportunity to provide a critique of Ms White or her integrity as a planning witness in evaluating the evidence in front of her.
Well, what are we doing?
Ms Hamilton.
Are we talking about fact or fiction here?
Ms Hamilton, you are representing these submitters. We've been provided a summary statement which is not being read.
Yep.
We have received written evidence which has been pre-circulated. This is not what we've allowed time to hear today.
No, I appreciate it.
We've already used up the half hour that you had allocated. We want to hear very much from all of the landowners who have provided evidence. I think that that's enough.
Is there anything, Mr Hart, that you want to talk about in terms of the effects of the rules that might be helpful for the panel?
Yes, the boundaries that have been put in place.
Really about how it affects your
Yes,
activities.
okay, the boundaries that have been reduced to 250 metres on the surface of it, it seems a concession, but it's ill-defined what an existing activity is. When I look at the changes of land use that have happened in the last few years, for example, Marlborough, dry sheep country to grapes, Mid-Canterbury, the giant state forests that Ngāi Tahu own, gone from forests to dairy pasture. If you look at Mid-Canterbury this week, Turners and growers are converting a dairy farm to an orchard. Now, the issue is that an existing land use? Now, we're told that it is, and that's good. I support that. But looking at it from a farmer's point of view, it does seem like a change of land use. So do we proceed from here, relying on your people's word that it might be acceptable, but do we find in 5 years' time we end up in dispute over it as to whether it is an existing land use or whether it's not? It's not clearly defined at this point. So the other point about it is, if it is an acceptable land use, then what is the point of the boundaries or what is the point of the overlays, the 250 metre? Why not take them away altogether? Because despite all the things that we're supposed to have done wrong, we've got these sites through in really good condition without any boundaries. So if you say, well, those things are permitted activities, what else have we got to worry about? Because if you look at the major changes that are likely to damage these sites, for example, setting up a lime quarry, subdivision, roading, that's all covered by the regional council process. So why is the Timaru District Council getting involved in this? It's an unnecessary regulation. So I think the other point that hasn't been covered to date, succession. I sat in on the panel yesterday and I sort of took it that the panel doesn't have to be too worried about financial impacts, but already the proposed planning overlays on properties are meaning that some properties are unsaleable. So if you take a farmer that's reached the end of his farming life, he has to retire, he can't get out because he can't sell his property. Now you can say, oh, well, that's just one or two people, we can't be worried about that. But over time, 10 years, you're looking at 25% of the farmers, 40 years, you're looking at them all. It's a process of renewal, and I don't think you should put something in place that's going to stop this from happening. So,
Mr Hart, we really do need to wrap it up because you've got a number of other landowners who wish to be heard this morning and we're running out of time. The panel is now going to take a 15-minute break, which we have scheduled, and then we will return and see if there are any questions for you from the panel before moving to the next one. Thank you.
Sorry, Georgia.
We're back online. Thank you very much. Mr. Hart, the panel doesn't have any questions for you. We're also mindful that you had the opportunity to speak to us in hearing stream D, and we have your written submissions and summaries. So thank you very much for your attendance. Ms. Hamilton, just in terms of going forward, look, the panel is well appraised of the concern that landowners have regarding the process leading up to the notification of the plan. We do have the ability to limit undue duplication of material in the hearing. We don't wish to hear any more about that part of the process. The panel's particularly interested in how the landowners understand or perceive the proposed provisions will impact on their farming activities. We're also very keen to hear about the initiatives that they have undertaken themselves in terms of the protection of the cultural values that they are aware of that are on their site. So with that in mind, I invite you to...
I've just had a chat to them all and they focus on that, so that was the plan moving forward too.
Thank you very much.
Conscious of time as
yes,
well.
very much conscious of time, and an apology too to Mr. Hull, who's been waiting patiently to be heard before the morning tea break. I hope that won't inconvenience you too much. Thank you.
Thank you, Commissioners. My name's James Fraser, and we farm in the Hazelburn, Totara Valley area with a property located at 228 Raincliffe Road, which is irrigated and consented for intensive dairy grazing, beef, sheep, and we grow processed crops on our property as well. 87% of the property is covered by SASM. That is located, or they are located on a limestone escarpment. There are numerous drawings or remnants of various stages of decay, basically, as time erodes them. We strongly empathise with the cultural values of Māori with respect to these sites, and we've worked hard with our own initiatives to fence off and protect these sites. And that's evidenced by the glowing reports from Māori Rock Art Trust in our Farm Environment Plan and recent Land Use Consent Renewal, which covers all those aspects, and it has it's particularly interesting that there is absolutely no setback noted in any of those reports, and that has just been done in the last few months. So I don't see a need for this extension of 300 metres whatsoever. The fencing off we've done is 10 to 20 metres from the rock art, and for the most part we don't graze that at all, and yet this is where contradictions come in with the various parties in it. The discussion so far has been a bit linear, that it's been just rock art and farmers, but there are 2 or 3 other parties that are having an impact on the management of these sites. The Department of Conservation, the BAT people, and ECAN, and it's just a shambles. So why extend it 300 metres further out and create more of a shambles? In the 50 years that our family has owned this particular property, we've never had any Māori come and ask to view these drawings. And yet they're deemed to be of such significance that they need to be, the protection needs to be extended so far. To me, clearly, there's not a wide interest in these drawings. But I know I'm risking going down a different path. I share the other concerns of Limestone Group members around the process. I'm still concerned that the extent of the SASM overlay on our property is excessive. Without the proposed change or our recommended change to 10 metres, there will be an effect on the value of our property. I believe it is relevant to the hearing's consideration of submissions, the unjustified extension to the outlay. I support the additional changes of the Limestone Group, and I know you're interested in examples of how it would affect our business, and we're predominantly a cattle operation. We run up to a couple of thousand cattle, and if we wish to build some cattle yards on this property, we'll need to get a consent. 90% of the property effectively is covered by the SASM as proposed. We'd need to get a consent. The property's within the command area of the Apua irrigation scheme. It's entirely able to be irrigated. We irrigate right up to our fenced off area. Irrigation is a moving target of technology and development. Improved efficiency is construction of dams, extension of main lines. We'd need to apply for a consent to the District Council for this, or through Ngātahu. The limestone soils are well known for attracting interest in the viticulture industry, and we have looked at this area of opportunity as well, and the work around that would likely necessitate a consent application as well. And this is it's all about the cost of it. Discussion around the values yesterday. I listened to the YouTube, the presentations, and we're consented under ECAN to irrigate. Under this proposal through the District Council, it opens up for this assessment and setback. Now, it could, if it reduces 1 hectare, it costs $10,000 a hectare for the irrigation right and $10,000 a hectare for the development. It's $20,000 a hectare. We can't do that. Where's that value? We're required to go to Maori for consultation under our farm environment plan and under our land use consent. Why go through this again through the District Council plan? It just seems unnecessary duplication. And I've spoken about the various parties that have interests in these drawings in my submission clauses 31 to 33. But in summary, the protection of the art is a shambles with various parties involved on our property. The biggest concern that Maori have is about the vegetation around it and the gorse, the blackberry and other weeds, both native and introduced, that are risk shading, encouraging the growth of mould, they encourage the use of stock around these drawings, but half of them are in a SNA that you're not allowed to put stock in. Well, what are we supposed to do? I invite any questions.
Thank you, Mr. Fraser. That's very helpful to hear about your concerns in a specific and focused way in terms of your property. It's very helpful for us to understand that context. I was interested in your evidence statement where you've talked about the potential for impact on property values. So you've just talked about some of the potential loss of value in terms of irrigation. Those activities are already controlled through the regional planning framework. So am I correct that you're still concerned that the district plan is further controlling irrigation, or?
Not irrigation per se, but they are saying that you can't irrigate within the setback is not going to say that you can't irrigate within so many metres from the rock art.
Not in this plan. That's a regional council function. So as part of your water take, water use, all of your farm environmental planning, that's all controlled through the regional planning framework. And so on page 10 of your evidence, there is a section on the impact of the proposed rules, and they relate, as proposed, they relate to earthworks, mining and quarrying, and woodlots or plantation forestry. So in terms of those activities, are you proposing any of those activities in the immediate future that you're concerned about?
Oh, well, we have forestry on the property within 10 metres, probably, or 20 metres. We have a house, in fact, on the property within 10 or 20 metres.
And you're not proposing any mining or quarrying?
No.
No? And earthworks?
The development of cattle yards involves foundations, covered race and head bale area and so on.
Thank you. And in terms of property values, you've mentioned that in your evidence, you mentioned there's a potential for the value of your property to diminish. Have you got any direct experience of that occurring with any investments, any consultations with bankers?
Well, of course, these regulations are only a few months old, aren't they? So there hasn't been a direct with respect to rock art. However, what we're talking about is rights, isn't it? The rights of parties. And that's quite well established in irrigation rights or land use rights that have a significant effect on value.
Yes. I'm aware of that in the Otago context. Definitely, that's been a big thing in terms of irrigation and farm development and succession. But in terms of this plan and any overlay, I guess there are lots of planning tools and techniques in relation to protecting trees, protecting landscapes, protecting heritage buildings, which all use a similar approach in terms of overlaying a value on a piece of land. So I was just interested in if you've got any direct experience with any other overlays that may have impacted on property values.
We have a number of historic buildings, category 2 on the property, which I would consider an asset. However, I would not buy this property again if it was put on the market. I would not buy this property that's subject to the SASMs.
Right, okay. Thank you. That's no further questions.
Thank you. It's good to talk through the examples, and I think the two examples you gave were the building of a stockyard and intensified farming. And with this rule framework, the reporting officer, there was originally a rule put in about intensified farming, Rule 6, and the reporting officer has proposed that it's removed, and that's been supported by the cultural expert as well. So I'm confirming that you support that rule being removed.
I do. It wasn't so much it's about the land use change aspect and probably around the definition of mining a bit, or the cattle yard work and the 2,000 square metres. Here we've got a vineyard opportunity that may require a greater level of soil movement to do this, and that would require consultation.
So if you were planting a vineyard, does that come in, is that already on cultivated land?
Yes.
Right, okay. Because cultivation's also excluded, there's no rules for cultivation either.
No, but it's not necessarily that you would just do cultivation if you're landscaping
Right.
for viticulture development.
Right, okay, so there could be earthworks involved as
Yes.
well? Yep. Okay, that's really helpful, thank you.
My question is really, given that you've gone through it, I'm just curious to understand exactly who it was that you consulted with and which party as to when, because I've heard the Rock Art, was it the Rock Art Trust specifically, or was it the Bruno? I'm just curious to really
Yes.
understand clearly who
Yes.
were the parties that were involved there. In fact.
Under the LUC, land use consent, we were directed to AECL, who employed the Rock Art Trust to come out and inspect the drawings. And their report forms part of my submission, parts of, and I will provide you with the full farm environment plan and the land use consent.
Great, thank you. That was really helpful, just understanding that link. Thank you.
I don't have any questions, but I just want to acknowledge your care, your generous care, and your family's generous care of the Rock Art sites. Thank you very much.
No further questions for you, Mr. Fraser. Thank you very much for your presentation.
Yep. Good morning, everybody. Thank you for your time, the panel. My name is Mark Chamberlain. We're farming in Totara Valley. We're sheep and beef farming, finishing sheep and beef. My submission, I'll take it as read. We've always we've had our property for 30 years. We've always felt privileged to have the Rock Art on the property. Now we're a wee bit worried that it is probably a liability to us. Depends on the outcome of this district plan. We've worked in the past with the Maori Rock Art Trust. They came quite a few years ago and surveyed the drawings on our property. Photographed them all and advised us as to how to look after them. We've looked after them to the best of our ability, and if you probably lined up a photograph that Brian Ellingham, an archaeologist, took for Ngāi Tahu, or for the Rock Art Centre years ago, there wouldn't be much difference in some of those sites today. We've looked after them, and there's some very weak drawings that were weak years ago. There's a couple of very strong ones that are still strong. We don't let people too near them. We were told not to let people touch them. The sweat off the palm of the hand will degrade the ink. So we've followed advice, kept weeds down at our own cost. We've sprayed noxious weeds and kept vegetation back to look after these sites. So really, going further, we've farmed our property in a way to retain the natural environment as much as we can, sometimes to the detriment of probably total production. But we've now done a farm environment plan. We weren't compelled to do it. We haven't got any consenting activities on our farm. We're not irrigating, but we have voluntarily done it at our own cost. We've put our farm through an audit process called Farm Assurance Plus to a silver standard, which is around animal welfare and farming practices. This year we're going for the gold standard, which is environmental, quite a lot of more environmental things. So we feel that we're doing our best to look after these sites, and we've also got historic buildings, we've got historic lime kilns, there's all sorts of stuff on the property, and we work with all of these things to maintain them. To the Totara Valley area, the district, and most of these farmers here today are in an area that's semi-intensive. It's not massive land areas. So if you look at the photograph on page 4, if it was in front of you, our rock art site is at the base of a high, 150-foot high cliff. If you went 250 metres, if you went vertically up from that cliff and went 250 metres back, you'd be into some of the best productive land on our farm. We're reasonably hilly, but there's some flat land on there that's really productive and very useful to us. And if we wanted to change land use on that part of the property, we don't want to feel restricted, and we think the 250 metres is very restrictive. That's why we agree with the group's proposal of 10-metre setback, and that would give us options further out. As we realise that the rock art needs protecting, and 10 metres will do that, we feel that the cultural values there for Maori will always be there, no matter how far or how close to the rock art the land use change is. So the land has changed since the Maori were there. It's all been cultivated and grassed and run sheep on it. If it were to change to horticulture or something else, their cultural value is still there, just the same, and that won't ever change. And that's why we feel the 10-metre protects the rock art. The cultural value's way wider and probably can't really put a circle around it. So really the summary you've got in front of you there, but the points in there are that we feel that our land value will be compromised, as Mr. Fraser said, with the restrictions. We want to keep the restrictions as minimal as possible to do the best job we can for the sites and not affect our land value. Further down the track, we don't know what will happen. We may want to sell the property and it could be quite a restriction. So I would ask the hearing panel to make a sensible, realistic decisions, good for all involved, and afford appropriate and evidence-based protection of the rock art sites in the Timaru District Plan. And that's really all I've got to say. I agree with Mr Hart earlier that we feel really let down that we weren't consulted in the first place, because we've got a lot of knowledge. We've been 30 years there looking after these sites, and that would be the strongest point I'd have, that we weren't consulted. It was just a bombshell dropped on us.
Thank you very much for that. I'll
Thank
see if
you.
the panel's got questions for you. We'll start with-
Thank you, Mr Chamberlain. That was helpful to hear your the articulation of, in your view, the appropriateness of the 10-metre value, and also interesting to hear your understanding of the kind of wider associational values of a cultural area. We've heard some evidence around the rule framework as currently notified, and around the fact that the 300-metre buffer zone or the 250-metre buffer zone is a trigger rather than a hard and fast condition that would have to be adhered to. And we've also heard evidence that if and when, a buffer zone, regardless of the metric, the buffer distance would be a trigger for then a closer examination of what's been proposed, and then depending on the impact of what's been proposed, that would then inform an appropriate distance for the buffer. Does that give you any comfort in terms of what might, if the regulation framework continued with the buffer approach, does it give you any comfort that there would be a deeper analysis and consultation with the landowner, Rock Art Trust and the council staff around what would be the definitive appropriate buffer distance depending on the site-specific information at hand?
It would, in the way that you've just worded it, but we don't know in the future that if it is just a trigger now, that's fine. But I would like to see it kept in as small as we could, because in the future we don't know how strong those trigger points will be. They may change. At the moment, we may want to do something and everybody agrees. Further down the track, 20 years down the track, somebody wants to do something and there's stronger trigger points, which are a burden to our property. And that's the reason for 10 metres.
Thank you. That's useful to understand that future concern around what possibly could happen with that regulation. But as it stands, in terms of how that trigger might function, if it were to be pursued, you would take comfort that you could have that kind of level of deeper conversation at that consenting stage.
Yeah, that would be welcome, the consultation, but I still think that we need to keep it in smaller, so it never needs to happen in the first place for a lot of things. For some things, earthworks or heavy forestry or whatever, we realise it's got to happen, but for general, yeah, I think it's still too wide. Yep.
Thank you very much.
Kia ora. First, congratulations on being Lamb Supplier of the Year 2018 and finalist last year, and good luck with going for your gold standard FAP, because that's really showing your guardianship, and so well done. I have questions about the 10 metre. So in this proposed plan, the rule framework is for forestry, mining and earthworks, as it's been proposed by the reporting officer. And I wanted to know, with your land above, your really useful land, if that was to be, is there an intention to forest up to, or mine up to 10 metres? And if it were mined or forest up to 10 metres, would that have an impact on the rock art?
Yes, it probably would. I've put in my submission that for heavy earthworks or forestry that it should be looked at, and I've suggested maybe 50 metres.
50 metres.
And that's up to the panel on their research to decide how big that should be, but I'm sort of thinking that they should be separated out. Heavy earthworks and forestry should be taken out of it, and the 10 metres should be for other land use changes that are less invasive.
Okay, thank you. Because what we have here is really about forestry and mining. Specifically, those are the rules that are set with this plan. And when it comes to the forestry in particular, through your experience in using the land, would what we've heard in evidence of the two expert evidence was all about water extraction and irrigation onto rock art site, which is not being controlled in this plan at all. But what I'm interested to understand is, does forestry change the water on that site, and how far away should forestry be from a rock art site?
That's probably on an individual case-by-case basis. On our particular sites, forestry wouldn't, other than shading if the trees were too close, it wouldn't affect the water. But some sites it may do.
Right, because I was thinking that the roots might extract water, which would dry the rock art site out.
Yeah, on our particular sites, trees wouldn't grow anywhere near it. It's rock.
You wouldn't?
Yeah, it's just rock. It'd
You wouldn't grow
be
forestry
30,
up
40
to
metres before you'd get a tree to grow. Yeah,
Right,
in
okay,
places.
thank you.
Yep.
I'm interested in your experience of going through a farm environment plan without being required to. And, excuse me, and just in part of that, in terms of, was there consultation or anything undertaken in relation to the cultural values as part of your farm environment plan?
No, not cultural values, no.
Can I just make a comment there, because it might be helpful in terms of context? So my understanding that Mr Chamberlain's land use does not trigger a resource consent for farming under the regional plan, and so it defers to that, I think it's called a farm management plan, which just sits with the landowner rather than part of an FEP, fuller FEP process.
No, I understood that,
Yeah.
so I understand the difference. I was just curious
about the consultation
about whether there was a different approach taken when preparing that. Thank you.
So just on the farm management plan, farm environment plan, we did it voluntarily to achieve our FAP plus to a gold standard. We had to do it.
Yes.
It was the first step in the FAP plus program, but that was voluntarily as well. So yeah, thank you.
Thank you very much, Mr Chamberlain. I have no questions for you.
Thank you.
How are we tracking? It's you.
Good morning. Well, thank you for listening to our submissions and what we have to say, because I think it's very relevant to get it from the people that it affects, because it actually is quite narrow within our area of the affected people. But you know who I am, you've got it in front of you, so I won't go through that. But I'm an 81-year-old farmer and have been around for a while, and I've seen a lot of these. Our farm's been affected by, I started a lime works, I've done various things. I've been very affected by a lot of the legislation that's gone before us. I've fought it on several occasions on our homestead, because it's a very large 150-year-old tree garden, etc., etc. So I've had a lot thrown at me in this aspects. None of it was done in consultation, which is sad. But we'll go on from there. That was just a further outline. And part of our property is subject to the SASMs and significant area to Maori. And I could go on and embellish that of why it was and how it was, because I actually know quite a lot about the involvement of our farm with Maori. So, as much to say that we've never had any Maori to actually come and ask me about this and that, or look at it, or help me, or help a farm. We've tried to do it with bats and etc. And the name of our property is significant to Maori because it means the laughing owl. And the laughing owl is where they make the cloak, and it's still relevant today. They make it in Nelson, and it's still relevant today. They're now extinct, but the bats aren't. That says to me something, which I won't elaborate on because I might get into trouble. And so a lot of the changes, I don't have a problem with. I don't have a problem with having the sites of Maori drawings preserved. I don't have a problem with that at all. All I want is to be included in it, not excluded from it. So we can have a participation, because the farm has been in our family for 100 years. We've done our best to do it on the situations we're in. But now we feel we've been excluded. We've sprayed the gorse, we've looked after this and that. No money has come across from any way, or any deed, or any helping us, how it's significant, why it's significant, what we should do, etc., etc. It's been on our validation. I find that not very nice. I don't, and the SASMs on our property are basically land. There are small drawings that actually can't be seen without a proper light. I find that difficult to believe, because as I said, I've farmed all my life, and one of the reasons we're still there is to be able to be quick with decisions about what society has put on us, to be able to make that decision so the family can still stay there. Because we have huge problems within the farming community of getting spouses, etc., sorted out, because these farms seem to be worth a bit of money. And so we have to be quick with what we do. And part of the problem that I have is that, and I don't want to be rude here at all, but each generation in the Maori situation, they used the area to gather the food. And that's wonderful, great. That was those years. These years have changed. Farming has added a huge amount of prosperity to the country, people, all of us together as New Zealanders. And so that has to be protected so that we can move quickly, effectively, and still encourage diversity in tangent. Well, I've gone off the bottom of my page a bit here, haven't I? I really protect the group, as I said before, because we're a group and a lot of us affects only a small area. We have increased costs and rates, etc., etc. Our farming activities are costing more and more each year, so we don't want another layer of consultants, etc., to be able to bring up all these new things that are coming upon us. We don't want that. We want it done in one. We're happy to work together. I suggest that if this process had been where they'd got us in the room, we'd have had this done in 5 minutes, because we're not against it. We're for it, but we want it done on an individual basis, because each Maori drawing is actually different location, different, etc., etc. And so that would have been nice, and we could have done that easily. I have an instance when I started the Limeworks, which we won't go into, where the so-called experts was a draconian experience, and they were in the wrong area. They had the wrong map. And so I'm slightly where are we? Yeah, I think it's not the Maori drawings, but the land is probably an infringement on our property rights. Because, as I said before, if we have to have another layer of asking what we can do, which often takes quite a lot of time, we might have lost the effect of what we want to do. And so we must be free to do that, as the Maori were free to do what they did in their time, in their land, to how they fed their people, and that's fine.
I wonder if you could help us, just, and time really is getting of the essence, and you've got another submitter to be heard. Can you give us just to short circuit this, some examples of where the rules that were proposed in the plan as notified, or those that are now being recommended by Ms White, will actually impact on your farming activities, just so that if you've got anything in addition to what the other witnesses have said about the impacts on their properties, we'd be really keen to hear about that.
Yes, the definition of earthworks, for instance, slips on the property. We just as a quick example, we'll have a slip for a big rainfall. We fix them, we cure them, but we're going to have to get a consent to be able to do that. I don't see why we should have to do that, because it would be considered under here major earthworks. As an example, we have to put tracks in on the hillside now because of health and safety, because we want, the modern motorbikes and modern people, if they go off onto the steeper country, they roll the thing over and then we're responsible. So we put tracks around our farm so that doesn't happen, so they can muster them, because we're on hill country. Why should we have to have a consent from someone to be able to do that? When it's in 2 years' time, it's back into grass again. And we make sure that when we do it, we put in alleviation of water runoff, so it's not going to just run. We capture it and then let it filter down. And then secondly, plan public and social occasions, including carnivals, fairs, markets, auctions, displays, rallies, shows, commercial filming, video production, dog trials, concert. I can't understand why dog trials. That's part of who we are as farmers. I mean, dog trials are amazing, and it encourages the young to be part of the farming community. We're going to get consent to do that, and yet it's what we do every day. I just can't work that one out. Public meetings. If our country is full of bats, we've got people who want to come and see them. Is that a public meeting? I mean, I don't know. Sorry.
Clarify, just our reading of the rule is that any temporary event within SASM 8 or SASM 9 is permitted as long as it's outside a significant natural area. Were you aware of that?
No, I've actually I've relied on my legal counsel to give me some of the things.
Well, the difficulty is that we've got a notified plan that would control that, and then we've got a suite of revisions, and so in part we're having to deal with the both sets.
And that's absolutely fair. No, not wishing to suggest otherwise. It's just we were just reflecting on the rule drafting, but understand that there's a difference between what was notified and what has been recommended. And some of these rules have immediate legal effect, so I do understand that. Mm-hmm.
So my proposal is, to finish it off, that SASMs should be put on areas of covenant areas, which we have areas of bush beside us where this kakahu owl eventually lived. So it should take it off private land and put it on, and there's plenty of areas, Kiwi Trust, covenant areas, etc. Fine, because that actually encompasses a lot of other rules, and it would satisfy us as farmers to be able to be vigilant, and we are ruled by society at any rate on what we can and we can't do on our farm. Society decides a lot of that, which they're doing now. And so I don't have a problem with that, but I do have a problem of another structure of, and can't, if the Maori is important, be incorporated within the council rules, not as another layer. And I think it should be just for the covenant areas, and there's plenty of them around us. And you've seen on one of your of a photograph of our property in 1906. of horses ploughing an area that's now Sazins, and then you look at it now in our ownership, where it's now covered in bush and it wasn't then. And so that's where I struggle. Thank you very much.
Thank you for that. That's helpful, and the photographs particularly useful. Thank you.
Just one more thing. The value, whether it will decrease the value of my farm or not, history will be the judge of that. I cannot tell you that now. I suspect it will if we have too many, but I'm not saying, and I can't categorically say that it will, but I have a suspicion. But it's what can happen from now on. Sorry about that.
We won't ask any questions. We need to move through to the next submitter, but thank you very much for that.
I'm wondering, Madam Chair, whether you might take Mr Evans's summary as read. I know you won't have had the opportunity to, but maybe. I know that you've read his evidence in full.
Yes,
so
happy to take it as read, and if
helpful.
he can just address the
Questions.
provisions.
Yes.
Thank you.
Thank you. In light of this going on for a while now, I'm going to attempt to be very punctual and concise.
Thank you.
My statement described the interest our family has had in discovering and protecting cultural values long before any legislative controls where these now exist. This is going back to 1874 when my great-great-great-grandfather settled. I've already detailed in my statement of evidence the magnitude of existing controls, largely from a regional level and a national environmental and national policy statement level, which has subjected our farm to the consents to farm a forest, abstract water and use water and disturb the riverbed. And our farm environment plan considers cultural effects and, as applicable, management of rock art sites. We've also have the voluntary farm assurance program, including FAP Plus, and that is audited. And I have identified that the freshwater farm plan regulations 22 under RMA Part 19A require that farms have a freshwater farm plan, and this also considers cultural values, catchment context, and is subject to an independent audit. So we have had 5 audits in the past 3 years from our voluntary programs, industry programs, regional council, and often these duplicate the same things. Another audit for the freshwater farm plan, and they recur, so we're looking at another audit. So I guess my main point is that there are a lot of existing controls with our activity concerning our rock art sites and concerning our management of cultural values. I have a section on existing use rights. I won't go through it, but there is a part in the 139A Act about being continuous within 12 months. That's clearly a problem for farming activities where we may not irrigate owing to climatic conditions, forestry and like have a return period of more than 12 months. Some paddocks aren't winter grazed or cultivated for 3 to 5 years, depending on rotation. So I am a little hesitant to rely on existing use rights, but that is a common phrase used by planners in responses to Lagoima to appease concerns, and I don't believe it's totally founded. I'm just going to go through a lot of this because I'm conscious of time. Concerning the requirement to obtain cultural advice, our experience with Aoraki Environmental Consultancy Limited has been very productive, constructive, and reasonably priced, and we have welcomed their input concerning our farming activities. Additionally, the Rock Art Trust has done amazing work in our district, and they ought to be commended. And I would not hesitate to be reaching out to either of those parties should I have any concerns about my farming practices or the need to engage prior to an activity. This is just a really good example of constructive landowner engagement and leading to good outcomes. I guess one point I've made, and as these processes evolve, and I've listened to your questions to submitters, is that we all develop an understanding as time goes on, and I guess I come away from this feeling, in some respects, quite upset, particularly given my great-grandfather was so involved in discovering these rock art sites, working with Hapu Iwi all those years ago, that this chapter has evoked such passion and strong language and things that make me feel quite uncomfortable as custodians and caretakers. And I feel, as I reflect on my great-great-grandfather and his colleagues, how upset he would be with the position that we are in. I really recognise the work that Ms White has done to make a lot of the rules within the proposed SESM chapter significantly more workable, to the extent where you'll ask me what is my problem with it, because all our concerns have been addressed through particularly the removal of intensively farmed stock, which includes our irrigation. And I guess I'm a little surprised that that these were proposed in the notified version in the first place, when there's been such a redaction through the S42A process to get to a point now where there's really nothing there that I'm uncomfortable with aside from the physical boundaries themselves, and that is what's evoking the passion amongst the community, I suspect. And I am actually wondering, well, what are we left with? And it's really boiling down to mining, quarrying and forestry, which are the significant activities that really require the controls, and therefore we can work to identify those areas of significance to Maori. I mean, I just consider our whole farm to be significant to Maori. I consider the whole district to be considered to Maori. In the same respects, it is important and of value to us. That really leaves it. There is one little point, and it's talked to a bit about temporary events, another activity that I struggle with, having been in the notified version to start with, and you've heard the list of things. A group of 6 commissioners, I would believe, would meet the definition of a temporary event, noting that that would have required a resource consent with full discretion, being a non-complying activity, and that has been removed. But most Maori rock drawings are in SNAs, including our one, so that rule would still apply, and I don't see why the SESM chapter has got a point in there about regulating what temporary events happen in SNAs. A side note. Finally, I'll conclude this with recognising and thanking the Timaru District Council team who have facilitated this process to date. They've clearly communicated with submitters, addressed any queries and provided easy website accessibility with the proposed district plan, planning maps, statutory documentation, etc. And I think the Timaru District Council team should be very much congratulated on that side of the adoption of this plan. Thank you.
Very much for that. I'll just check and see if there's any final questions from anyone.
Thank you, Mr Evans. Appreciated your presentation today, in particular your acknowledgements of the efforts of all parties and your acknowledgement of the fact that this is a process that unfolds, and through the contribution of submitters like yourself, some changes can be made. That's very much expected part of a process under the Resource Management Act, which we're all very familiar with. I would just like to acknowledge your role in that. I've understood your submission, and that your remaining concern relates around the buffer metric, the meterage applied to that buffer zone. So thank you.
Kia ora. The only thing that I'm hearing, if I capture what we've heard today, is a differing perspectives of engagement, and I just wanted to acknowledge that everybody's have their own perception of engagement and whether it's gone well for them or not. And this particular process under the RMA has tried to acknowledge that through history, mana whenua have been disconnected and displaced from their whenua and their ancestral associations to their land. And the planning framework is really meant to bring back their voice into their place because they say they belong to the land. And what I've heard is, to some, it's gone too far because they've been excluded from the process. So I wanted to acknowledge that there is actually different views in the room, and some that say the experience has been good, and some that say the experience has been bad. And it's really interesting to hear from each of you today about your own experience and how these rules will actually impact on your land. And I'm looking forward to going out to the site visits. So thank you for today.
No, I can't add any more to what my colleagues have said, but I just want to thank you for your submission. It was very clear. You stuck to what you were meant to stick to, so I thank you for that.
Mr Evans, thank you, and that's been most useful to have another example of an experience with the process, both in terms of the development of this plan, but also in the consenting process, both at a regional level and a district level. And we will obviously reflect on that as part of our deliberations. So I don't have any specific questions for you. Okay. And similarly, we look forward to the site visits to give us a little more context of the on-the-ground activity environment that we're dealing with. It's the plan bites, I guess, at the farm level, and it will be useful for us to see that. So, Ms Hamilton, thank you for your presentation. Unless you've got anything further to add, we'll leave it there. It's possible following the site visits the panel may have questions.
Of course.
And we'll issue a minute and seek the views of yourselves, and it may be necessary to receive input from council planning team
of course,
as well.
yes.
Thank you.
And if you've got any questions around that proposed itinerary, we're more than happy to answer those ahead of time. The only other thing I just wanted to cover off, and it's really more a suggestion about how we land the question from Commissioner Mackay around that earthworks rule in Wāhi-Tapu sites. So I've had a quick look going back to it, and I can see that under the notified plan it was restricted discretionary, pretty much a blanket, and is moved to permitted. I think that the question's probably best answered by Ms White, and it is really around, was that intended, and also, if so, what's the rationale for it? And she obviously will be the best place to answer that. So that was the only final thing. And we will collate the FEPs, the farm environment plans and farm management plans from the group, and get those through to you as well.
That'll be helpful. Thank you very much. Welcome back, Mr Hole, when you're ready.
Thank you. Just put my glasses on. So yeah, I'll just, everything's set out in my statement of evidence, so I'll just briefly take you through that, and then happy to answer any questions afterwards. So in terms of energy and infrastructure, Our main submission there is in relation to trying to have a more enabling provision for the establishment of large-scale solar generation on buildings, in particular within the industrial zone. So as an example, the land owned by Rooney Holdings at Washdyke contains approximately 20 large-scale bulk storage sheds of varying sizes, and the most recent constructed at the end of last year is 8,500 square metres. All of these buildings have been constructed north-facing, specifically for the purpose to enable solar generation. So we consider that, given that it is in the industrial zone, that enabling solar generation on the roofs of those existing buildings or any new buildings is unlikely to have any adverse effect. And so while that technology around solar generation is evolving, the establishment of panels on roofs is largely unchanged. So a permitted activity rule providing for the establishment of large-scale solar generation on existing buildings in the general industrial zone would provide better regulatory support to landowners looking to implement this activity without requiring a full discretionary resource consent. In relation to transport, Rooney Group made a further submission opposing Timaru District Council's submission on Transport Rule 10. So that was in relation to high trip generation activities, and in particular trying to link that to levying a financial contribution in relation to heavy vehicle movements. So we're of the view that the change sought by TDC will result in new developments being penalised where heavy vehicle movements arise from the activity compared to existing activities, and this has the potential to restrict new development or activities establishing within the district. This inhibiting effect would have negative consequences for economic growth and would potentially suppress innovation and reduce resilience through increasing the costs of diversification. We consider that the Council's proposed plan should be designed to support rather than inhibit land use changes that provide a platform for the district's growth. And I have considered Mr Willis's recommended restricted discretionary rule that provides for an additional 5% of heavy vehicle movements. So while that's better than nothing, we still think it would be better if the threshold was higher. In relation to subdivision, was submitted in relation to Policy 7, which relates to Esplanade reserves and strips. So we fully acknowledge that public access provisions that's provided for in Section 6D of the RMA, but this is not an absolute and must be considered in the context of managing the potential for adverse effects arising from public access. I think it's important that it should be acknowledged that public access is not appropriate in all circumstances, and that's often, that is what the Esplanade strips or reserves often provide. They can result in adverse effects on landowners, and this is mainly in relation to rural land, such as poaching or dogs being off lead and then being able to enter adjoining properties. Not all stock classes are compatible with unfamiliar humans or dogs, particularly at certain times of the year or at various stages of their development. And deer are a really good example of this. The creation of a Esplanade reserve may result in an adjoining property owner not being able to use their land as they had previously, or needing to upgrade fences, which in itself may not be practicable depending on whether or not the land is susceptible to flooding. So Policy 7 does provide limited scope for an Esplanade reserve strip to be waived, and that has been noted in the officer's report. But it does not provide for consideration of a waiver where adverse effects may result from the creation of the Esplanade provision. So we're seeking an amendment to the exclusions in Policy 7 to recognise that where an incompatibility issue will arise with adjoining land use, such as threats to stock or an inability to farm or utilise private land. In these situations, the requirement for the reserve or the strip should be waived. Policy P7 should also provide for the requirement for Esplanade reserves to be waived for boundary adjustment subdivisions. And I've referenced the Waitaki District Plan and also the draft Waitaki Plan that provide clear exemptions from requiring Esplanade provisions for boundary adjustment subdivision. And these, if that change was made, then that could be clarified through the subdivision standard S8, and I've attached copies of those relevant provisions. And that kind of links with, it links to that subdivision standard S8. If an Esplanade provision is not required in relation to a boundary adjustment subdivision, then that should be made clear in the standard. And I guess the concern really is that a proposed boundary adjustment subdivision can occur where the affected boundaries may actually be quite some distance from the water body that's identified in the schedule requiring those Esplanade provisions. Yet it could still be part of the same allotment, and therefore that's what triggers those considerations. The concern is that the requirement will result in a landowner not proceeding with a boundary adjustment subdivision, which may have a detrimental effect on the primary production of the area, or that the use of the affected boundary will be compromised, as discussed in relation to Policy 7. Both these circumstances may lead to adverse effects that may not have arisen if the Esplanade provision had not been required. So when I talk about the adverse effects, I guess what I'm saying is an owner may seek to acquire some land off a neighbouring owner, and they may farm that land in a much more productive way than the owner that they're looking to purchase off. So that's, in terms of overall production, a boundary adjustment subdivision is a nice easy way for someone to acquire more land, and it may result in more productivity. So subdivision standard SA as drafted will result in council acquiring land for Esplanade reserves or strips where a proposed boundary adjustment subdivision has no consequential effect on the water body boundary for that reason I said before about the distances. So just in relation to the subdivision rule, R1 in relation to boundary adjustments, I've put forward an alternative in the submissions, just as using an example of the Westland District Plan, where they've had an operative rule since 2002 that provides for boundary adjustment subdivisions to be done as a permitted activity. And that has been carried through into the combined West Coast Plan in relation to residential and industrial zoned land. And I've had some experience working with this previously, and so while it's a little bit unusual, and like I was saying, it's a nice, easy way for people to kind of acquire land off a neighbour, particularly in relation to rural subdivision. You can still have standards on that permitted activity rule, like any other rule, and you're still required to seek Section 223 and Section 224 certificate from the council, so there is controls there, but all that is required is that a surveyor would do the survey, draft the survey plan, so that would be an LT plan, and that would go to the council for approval like they would with any other subdivision plan, and they issue those certificates, and that goes to LINZ, and the new titles resulting from the boundary adjustment subdivision come from that. So it's just, while it's unusual, it is possible, and it's just a much more efficient way of enabling a relatively low impact activity, in my view.
Mr. Hull, if I could just ask a question, do you have any information on how frequently that permitted activity rule is actually utilised? I mean, the conditions are still reasonably, I mean, it could be quite challenging if there were a number of buildings on the site, ensuring that they still meet all of the requirements in terms of setbacks and the like, or number of dwellings.
No, I can't tell you. I mean, yeah, it's quite some time since I worked with that, but yeah, it's obviously what the surveyor needs to do when they are engaged to do that work is they need to do an assessment to make sure it's going to comply with the subdivision will comply with the rule and provide advice on that basis. In relation to development areas, submitted in relation to development area 3, which is the Washdyke Industrial Development Area, and our main concern there is in relation to proposed Road 5 and in the standards that go with Rule 1. Mainly standards 1 to 3 in terms of how they're enacted in terms of when that road is required to be formed. So road 5 is a new road that would connect Seadown Road to Meadows Road. Excuse me. And that would result in the closure of the current Seadown Road and rail crossing, and so Road 5 is a new road that would also would require a new road crossing. And the issue with Road 5 is that it's a linkage across the Rooney Holdings land, and it's a road that is not necessarily required for the development of that parcel, which is sort of a 12.5 hectare site, and it's got development at the bottom end of that site being Brosnan Transport, and there's a shed 19 Rooney Farm shed at the north end of that site, but the balance of it is vacant. And so the real issue is what will trigger the construction of Road 5 and who's required to pay for that. One of the issues is making sure the design is included in those costs, because I think Standard 5 does talk about the apportionment of some of those costs, and so that does alleviate some of our concerns. But the issue really is if, for example, the Brosnan Transport site was to be expanded, which is some distance from where Road 5 is, but it's on that same site, would that trigger the requirement for the road to be formed, and who pays for it? And it really, it would be good to have some better direction in the plan on that. Yeah, and that really summarises everything, I think. Thank you.
Thank you, Mr. Hull. At paragraph 24 of your evidence, you are putting forward a solution that in your mind would resolve submitters' concerns, and that is to provide a waiver for boundary adjustment subdivisions. Have you done a Section 32AA analysis for that relief?
Sorry, I just missed that last sentence.
Oh, have you undertaken a Section 32AA analysis for that requested relief?
No, I haven't, sorry.
Thank you. And in relation to the Waitaki District Plan and the draft Waitaki District Plan, you'd acknowledge that a plan as drafted is not something that we can necessarily take into account in this process. But in terms of the operative district plan, can you describe a little bit more about the context of that waiver? My understanding is that subdivision boundary adjustments are subdivisions.
Yes, that's correct.
You're not disputing that. But in what context has that particular jurisdiction decided to waive an esplanade reserve for boundary adjustment? Is there any other information that would be helpful for us to understand how the implications of that pathway?
Yes, so in my attachment 1, which is from the operative Waitaki District Plan, so there's a heading there, exemptions from provision of esplanade reserves or esplanade strips, and then it then specifies in terms of those exemptions where a proposed subdivision is either, and then it lists 2 matters, and one of them is a boundary adjustment subdivision in accordance with Rule 14.4.1a.
Thank you. So it's not a blanket rule from the looks of it, is that correct?
So I understood that my interpretation of that rule was that where you were undertaking a boundary adjustment subdivision, then it was exempt from the esplanade reserve provisions that would ordinarily be required.
Exception at the end of the clause, how does that apply? In 4A, except for the margins of the following rivers. I guess what I'm interested in is it's not a, there seem to be some if but whens in that rule, in that exemption. Are you suggesting that in the relief that you're seeking that there's a blanket exemption, or are you seeking some more tailored approach?
I thought it was a blanket exemption because I thought it was considering a boundary adjustment subdivision to be a minor adjustment in terms of a subdivision.
Are you looking at B? Yes. Gotcha. Yep, I'm following now. So if you just talk me through clause B.
So clause B would be exempt from those esplanade provisions where a proposed subdivision is either, and the first one is a boundary adjustment in accordance with Rule 14.41. And I haven't got that attached, but I thought that was the general sort of subdivision rule. So if you're undertaking a subdivision that required, where you had a river joining, but it was a boundary adjustment subdivision, then that clause would apply.
Yeah. Okay. Thank you for that. That's helpful for me to just get my head around the rationale for why you were putting forward the Waitaki example. Thank you.
I just have one question, and it's about the Transport Rule 10. So that's paragraphs 15 to 18, 15 to 19 of your evidence. And I'm trying to understand. I think what you're saying is that floor area, so if we're looking at table 21, you're saying that the criteria of floor area and number of allotments is the wrong measure. Have I understood that right?
What I'm saying is that the table doesn't necessarily, it uses different criteria for determining whether or not a full integrated traffic assessment is required or not. It's not just about vehicle movements. I guess that is the table's kind of in terms of the rule that the submission is on, it ties to that table,
yes.
Which then there's a step involved in that, and through an integrated the traffic assessment, which you've then got to work out from that whether or not there's going to be an increase in heavy vehicle movements, and then if there is, then that's when it's linking to requiring the financial contribution.
Right, so is your submission therefore then that the table 21 is not necessary because you're doing assessment?
No, not really concerned about table 21. It's the just sort of setting out, I guess, how the plan steps you through that, or in terms of the submission point from TDC, what they've linked it to get to the financial contribution that they're seeking. But yeah, the concern really is
the financial contribution.
Yeah.
Okay, got it. Thank you.
Just to change the topic slightly, my question's around large-scale solar generation on industrial land. In Mr Willis's analysis, he said he did consider whether a restricted discretionary activity status could be applied. He was obviously concerned about the varied locations and types and scales of renewable generation. But my question to you is, yes, our concerns are around the adverse effects that it may have, but what is your experience or evidence around social and economic benefits that the solar generation on building roofs, as suggested, would bring? Do you have a view on that?
Well, certainly just as an example in terms of our business, often are asked about emission offsets, and so renewable energy would fit in that category exactly the same as, get asked in relation to carbon forestry, that those sort of offsets as well. So it definitely has a benefit from that perspective.
Yes. About permitted activity status for land-based solar generation on buildings in the industrial zone. I'm just touching on what my colleague has just asked you about. Yesterday I asked Mr Willis what effects are generated from having solar panels on industrial buildings. And he said they would consider effects from particular vantage points, so from the state highway, as opposed to what you've said just within the zone. So have you considered that?
Yes, and I did hear that question yesterday in Mr Willis's response. And I appreciate that it has been considered. The thing with the general industrial zone, it's quite a large area of land as well, and most of those buildings that are there, certainly on the Rooney site, are all in excess of 10 metres, so they'd be in that sort of 10 to 13 metre height bracket. They don't have high pitch roofs, so the they're relatively flat. So they're not overly visible. I think in terms of being visible from adjoining sites, and mainly, I guess, residential to the south, you would only kind of see them if you were elevated. So not, I don't think they'll be visible from too many sites, and I don't think they'll be visible from the state highway, not in an obvious way.
Have you done an assessment? Have you engaged an expert that kind of assesses that type of thing?
No, haven't got to that stage.
Okay, thank you.
Mr. Hull, I don't have any additional questions for you. Thank you, that's all very clear. So,
Thank you very much.
I think we've got Mr. O'Brien. Thank you.
Okay, thank you, Commissioner. My name's Justin O'Brien. I work for Rangitata Dairies. I'll just be short. I just really take the opportunity to say, give our support to the recommendations that Liz Wright's made in her Section 42A report. So I just want to reiterate our support. Really, our submission related to the policies 2, 5 and 8 in SASM Rule 1 and also SASM Rule 6. I guess our submission, this is relating to the SASM provisions of the proposed plan. So overall, we'd like to support the Office's recommendations or recommended changes to policies 2, 5 and 8 as outlined in the Office's report. With regard to Rule 1, the Office's report has suggested partly accepting the recommendations that we made with that, and again, based on the discussions and so on, Rangitata Dairies would support the recommended changes in Ms Wright's report regarding SASM Rule 1 in relation to earthworks, as that will enable reinstatement of existing farm infrastructure and so on. And as also noted in other submissions you've heard, SASM Rule 6 regarding intensively farmed stock, again, Rangitata Dairies opposed that rule, and we note that it's been recommended to be removed, and Rangitata Dairies would support that. So I really just wanted to reiterate our support for the recommendation changes.
Thank you, that's refreshingly short. I'll just check whether there are any matters to clarify on their submission. I think that's all pretty straightforward. Excellent. Thank you very much for your patience as well, Mr. Mr. Vaughan Henry, on behalf of Deborah Mill Beattie.
We good? Is it working? So I just, what I'm speaking about today is there's an irrigation ditch on our property. It's been put on the district plan as a SASM 4A to be exact. So just a brief outline on the area of Seadown. The area was first farmed in the 1940s as post-war ballot farms. The first person to farm our property was Peter Cummins. This ditch and many others around our property and area were put in to drain the land and allow an outlet for the irrigation scheme. This ditch also acts as a stormwater drain in heavy rain. I've spoken to ECAN, and this ditch is classified as an unused drain. From time to time, they spray it with glyphosate to control aquatic weeds. The ditch previously has been cleaned out over the years with machinery and in places has become quite wide. Was also affected by erosion in the 86 flood. The owner of the land before us has made many requests to the irrigation company for repairs and maintenance,
to the ditch, response from them was there was no money available for repairs, maintenance of the ditch on our property. And to be honest, with this being classified as a SASM, I'd actually prefer it be filled in and another outlet found. This ditch is exempt from the RMA, and if the RMA is scrapped, do we go through the same process again? And I'd like this recorded for future generations, that it is a ditch and not a waterway. The information supplied by the identifiers for the SASM is fiction-based and has no factual evidence. There has been absolutely no consultation with the owners. If there was engagement, this whole process could have been avoided for all parties involved, and we wouldn't be here now. Coastal erosion on neighbouring property with a stop bank between us and the coast will require moving inland at some stage. I have also spoken to ECAN about this, and there is a possibility of a redesign and moving of irrigation ditches in the area, possibly down C4 Settlement Road area. We have always had problems with trespassing, people harvesting aquatic weed and eels. When confronted by myself, the response from them is they are allowed to be there. No one has ever asked for permission to come onto our property. This sense of entitlement has to stop. I ask if there is assistance available from the council with signage, information, etc. I request that SASM 4A must be removed from the plan, and I have supporting documents for my submission.
Great. So just supporting documents.
So they were in my original submission.
In the submission that was
So there's a
filed.
drainage
Yep.
plan.
Thank you.
And I have found a little bit more.
Yeah.
And it's when the property was subdivided, and it's written at the time to say that the property, would you like me to read it out, or do you have a copy of it? You've got a copy? Yeah. Yeah. So I have the original drainage plan of the area. And then there's some documentation from the previous owner when she's requested information and stuff from, well, back then it was Levels Plain Irrigation, so.
Yeah, I'll just see if there's any questions for you. Thank you.
Thank you, Mr. Henry. I have a question for you about, in your submission, you were concerned around the height restrictions in one of the rules.
Well, if the SASM 4 is removed, then that goes away, doesn't it?
If we can just focus on the rule as notified, as you've submitted on, that would be really helpful to me.
Yep.
Thank you. So the rule as proposed, as notified, was, in your view, too short.
Yep.
5 metres. The Section 42A officer has looked at that and has suggested that would be amended to 9 metres.
Well, that's fine.
So,
that problem goes away.
Okay, so you're comfortable with that on that particular rule application? Yep.
The reason I have that is there's existing properties, and that. So unless you've got a flat top roof on your hay shed, you cannot store bales 3 high.
Thank you.
Yep.
That was my only question.
One question, and it's just to better understand your land. So you talk about, you've said it's a ditch, not, so
yes.
It's a ditch, but then how do people harvest Mahinga Kai? Is it a waterway?
That's the confusion. It's not a waterway. It's man-made, as it's written in there.
So is like physically, is there water there, or is it a dry?
There's water in there when they're irrigating around Levels.
Right, okay, thank you.
But because we're so lying, the water does stay in there.
Okay,
in
thank
parts
you.
of it. Not where it enters our property, but where it exits it.
Thanks.
We're only a few metres above sea level.
I've looked at SASM 4 and it says SASM 4A, SASM 4B. Are you on just 4? So you.
I don't have that in front of me.
Sorry,
What part's
SASM 4
4?
contains Puhuro Beach Road,
Beach Road, yep.
and SASM 4B is Waipopo, Waiatu, Te Ruati and Oraka Paua.
No, it will not be, just A.
Okay, so is the ditch the Wahitapu,
Yep,
the ditch itself?
yep. But the overlay is on our whole property, so we've got the 3 overlays.
So it's wider than the ditch?
As it states in there, it's been cleaned out over the years with machinery, so
No,
which
but
has
I'm-
made it wider.
What I'm reading is the SASM descriptions, and the SASM descriptions to me read wider than your drain. I just want to know the extent of the SASM. Does it cover more than just the drain or a wider area?
Some of the overlays cover the whole property, but I don't fully understand this. And like I say, if there's consultation with the landowner, we could have killed all this very early on. But
Okay, thank you. No further questions.
Thank you. Look, I think we'll just clarify. You said it was Wahitapu or Waitapu?
So we have a Wahitapuna overlay. We have a Wahitaoka overlay and a Wahitapu overlay. So that photo you've got there, there's ditches come down both sides of Beach Road, and that one comes through our property and it's its outlet to the sea.
All right. Look, we'll go back and look at those maps and descriptions based on what you've shown us in the drainage map. But based on the descriptions in the plan, it appears that it's wider than just the drain. Drain. No, not the physical drain or its margins, but a wider area and potentially matters of cultural value or significance in the wider area within that, not just the drain. But we will check that as against the documents that you've provided us, and we'll
But when you
take
say
that
it's
into
wider,
account.
it's because it's been cleaned out with machinery.
No, not the waterway being wider. I mean a wider area, like a circle or an ellipse across a wider area of land, not just the physical drain itself, okay? So, but certainly those drainage plans and maps are helpful to us to understand that. So thank you very much for your submission.
Thank you.
Look, the panel's going to take a lunch break now. We are running a little behind, and I hope that doesn't impact on Mr. Boyes. I know you're very patient, but we're going to hear from the Waipopo Trust after the luncheon adjournment. So thank you. get underway. Tēnā koutou, katoa. Resume hearings. Welcome back, Ms Walter. Thank you.
Good afternoon, Madam Chair, Commissioners. I appear on behalf of Waipopo Huts Trust and Te Koutari Trust as legal counsel. There are two witnesses giving evidence for Waipopo today. Elizabeth Stevenson, who is seated next to me. Ms Stevenson is a trustee for Waipopo and Te Koutari Trust. And there's Robert Kerr, who is a flood hazard expert, and he's joining us online. Waipopo has filed expert evidence in support of their submission on the proposed plan. In addition, each witness has prepared and filed a summary of evidence. In addition to that, I've filed legal submissions for Waipopo, and I've also prepared a summary of those submissions. So if the panel would find it helpful, I can speak to that summary now, or you can ask me questions alternatively.
I think it would be helpful just to talk to your summary, just keep it brief, and then the panel can ask questions. Thank you.
Yeah. I'd like to acknowledge, with reference to my table at paragraph 13 of my evidence, of my submissions, that there were a wide range of issues that Waipopo submitted on the proposed plan. Then it's good to see that the Section 42A reporting officer has been responsive to those submissions and evidence filed by Waipopo. In particular, the support for the rezoning of Waipopo land to multi-purpose zone, and more recently, support for the servancy requirements to recognise the special situation at Waipopo and Te Koutari. And to a large degree, all the issues are resolved between Council and the submitter that will be discussed today. Even so, these matters are of considerable importance, and the Trust, or Waipopo, does want to be heard today. Hence why the witnesses are present. And I'm sure that if you have any questions for them, they'll be happy to answer those. And so in summary, the case for Waipopo as the multi-purpose zone is appropriate and better achieves the objectives of the proposed plan than the open space zoning for Waipopo. Of particular relevance to the issue of zoning and future development of the Waipopo land and Te Koutari land is the history of both sites with respect to Kemp's deeds, the Kemp's deed including promises made but not kept by various Crown representatives to Kati Huirapa since the treaty was signed, to the present day. A key feature of this case are the provisions in the RMA that place obligations on local authorities in relation to Māori. Specifically, Section 8 requires decision makers in achieving the purpose of the Act to take into account the principles of Te Tiriti. Section 6E requires decision makers under the RMA to recognise and provide for the relationship of Māori and their culture and traditions with their ancestral lands as a matter of national importance. And Section 7A requires decision makers to have particular regard to kaitiakitanga when exercising functions and powers that manage the use, development and protection of resources. In my submissions, I outlined the legal framework for a rezoning application, which I'm not going to go into right now. Yeah, but in summary, I've adopted the colonial vineyard approach of identifying the positive and negative consequences of the two options, and in summary, I've set out the environmental positive consequences, enabling Kati Huirapa to exercise their kaitiakitanga, managing the Waipopo land according to tikanga, providing benefits to the conservation of Indigenous biodiversity in Mahinga Kai. And then I go on to economic benefits, and the rezoning will be a significant step in simplifying the approval of rebuilding of homes on Waipopo, resulting in fewer resource consent applications and a less arduous consenting procedure. And then there are obviously cultural benefits to this rezoning, in providing for the needs and well-being of Kati Huirapa, allowing them to maintain their connection with their ancestral lands, and reinforcing multiculturalism within the Timaru district. There are potential negative consequences from the rezoning. However, as this land has been used for housing purposes, the adverse environmental effects are well known and of those equivalent to an existing settlement. There will be some economic costs, and of course I'll just go down to the flood hazard, because Waipopo is currently within a high hazard area, as defined under the Canterbury Regional Policy Statement. And we have Mr. Kua providing evidence later on about the flood hazard, from a flood hazard perspective, but he sets out in his evidence the assumptions that ECAN made while carrying out their assessments. And in summary, in his opinion, they were overly conservative as to the actual flood hazard. And Ms. Stevenson will set out in her evidence that her knowledge of the history of flooding on the land, but that, in summary, there has never been any threat to the dwellings or people at Waipopo. And so Mr. Kerr in his submissions will set out a more prudent approach to flood hazard, recognising that there is uncertainty in terms of what the actual hazards are on this land, but also the duties of local authorities in relation to tiriti. In summary, the rezoning of Waipopo to multi-purpose zone will generate significant positive consequences that cannot be realised under the proposed plan, and the negative consequences can be mitigated. And so now I go down to paragraph 23 of my submissions. And we're talking about the application of the Treaty of Waitangi principles to this situation. And in general, the courts have adopted a case-by-case approach to determining what the principles are in respect of individual case. And as part of that sort of history of jurisprudence, there are some overlapping treaty principles, such as partnership, active protection, and redress. And your role as decision makers have been delegated to you by virtue of the RMA. And so that involves bringing into play specific provisions within the RMA which encode those treaty principles, such as Section 6E and 7A. And of further particular relevance to these circumstances is a principle that's developed through case law, which is where iwi have been found to have a considered, consistent and genuine view that a proposal would have a significant and adverse impact on their cultural significance, that the iwi's view was determinative of those findings. And so how do those principles apply, or which principles should apply in this case? And I've set out some relevant principles, beginning with rangatiratanga. And the trust vision for their land is set out in Ms. Stevenson's evidence, and at paragraph 13 she comments that the proposed plan frustrates Waipopo's trust's ability to carry out their vision for their land. There's further evidence on that in Ms. Stevenson's submissions, evidence. And this expression from Ms. Stevenson is an expression of her rangatiratanga as a trustee of Waipopo and as a member of Katihu Rapa. Katiakitanga is another relevant principle here. And in the evidence of Ms. Stevenson, she illustrates how the trust act as kaitiaki for Waipopo, for the Waipopo land, and how they would like to carry out that role in the future. And then moving on to redress, and Ms. Stevenson sets out in her evidence that how the various laws and regulations have restricted the ability of descendants of the original grantees of these reserves to build dwellings, and how the rezoning of the Waipopo land represents an opportunity to act on the treaty principle of redress to remove the open space zoning from the Waipopo land, which restricts their ability to build new homes, and rezone the Waipopo land to multi-purpose zone to enable the trust to carry out their vision for their land. So in conclusion, Applying the multi-purpose zone to Waipopo will better achieve the objectives and policies for the multi-purpose zone and Strategic Directive Objective 5V, rather than the open space zone for the land. The rezoning will give effect to objectives, relevant objectives and policies in the Canterbury Regional Policy Statement. And finally, the multi-purpose zone. Applying the multi-purpose zone to Waipopo will better accord with Part 2 of the RMA than the open space zone. In particular, it better accords with Section 6E, 7A and Section 8 of the RMA by actively protecting and providing for the relationship of Kati Huirapa with their ancestral lands, waters and taonga. So that concludes my legal submissions.
Thank you for that. I'll just see if the panel have any questions on your submissions, and then we can turn to your evidence. Yep, none for me? No, thank you. Look, thank you very much. That's very clear. If you can introduce your first witness, thank you.
Sure. My first witness is Elizabeth Stevenson. As previously mentioned, Ms. Stevenson has prepared a summary of her evidence. Would you like her to read that summary?
It's helpful to read the summary. Thank you.
So my full name is Elizabeth Stevenson, better known as Lisa, actually. My qualifications and experience are set out in my evidence. The summary of evidence sets out the key points within my evidence in chief. The settlements at Waipopo and Te Kotari are located close to the Opahi River. Waipopo and Te Kotari are part of Arowhenua reserves set aside after the signing of Kemp's deed in 1848 between Te Waiponamu, Iwi and Crown. The Crown has acknowledged that it breached its duty to act with the utmost good faith towards Ngāi Tahu. I consider that to this day breaches to the treaty continued for Kati Huirapa in relation to Waipopo and Te Kotari. The overall vision for Waipopo land and the Kotari land is to re-establish the village that once occupied the Arowhenua reserves by upgrade and redevelopment of the area for safe residential use, including for Māori social housing. The proposed plan frustrates the Waipopo Trust's ability to carry out our vision for the land. The Waipopo land is zoned open space zone under the proposed plan. This is contrary to assurances from the council that the Waipopo land would be zoned Māori purpose zone. The proposed plan places a high hazard overlay over the Waipopo land, and rules under the Natural Hazards Chapter make it a non-complying activity to rebuild homes under this overlay. The servicing requirements in the Māori Purpose Zone Chapter for new builds also do not account for the special circumstances of the Waipopo land. There are 28 lots on the Waipopo land, and there are 5 lots where we wish to rebuild. There are 20 lots where the homes are habitable or with some renovations will be habitable. At Te Kori there is one empty site with one of these sites has existing use certificate to rebuild the house the trust removed. There is no reticulated drinking water, sewer or stormwater infrastructure that serves the Waipopo and Kotari land. The key environment constraint affecting Waipopo land is flood hazard risk. While we are aware of the floods of the past, as far as the Trust is concerned, none of these events have impacted on the Waipopo land. Apart from surface flooding, there has never been any threat to the dwellings or the people at Waipopo. Waipopo land contains 5 derelict homes and 3 vacant sites. Where derelict homes have been removed, the condition of the derelict homes is so poor that it does not make sense for the Trust to attempt to repair them. I understand from the Perspective report that flood hazard planning controls will make it very difficult for Waipopo Trust to secure resource consent to replace dwellings located in the high hazard area. This creates a significant issue for Waipopo Trust because its vision for Waipopo land is that all the dwellings will be occupied to help re-establish the village that once occupied this land. The Section 42A report broadly agrees with Waipopo Trust's submission to rezone our land to Māori purpose zone. The Section 42A report also supports the zoning of Te Kotari land as Māori purpose zone. In my evidence, I disagreed with the servicing requirements in Māori purpose zone S4 for the requirement of 45,000 litres of potable water storage for new homes built in the Māori purpose zone. This is because the Davis Ogilvie report states that 30,000 litres is sufficient to ensure a reliable water supply, and requiring a large supply would frustrate the rebuilding of homes for the Waipopo Trust and Te Kotari Trust. I note that the Section 42A report officer agrees with this in her Section 42A summary statement as paragraph 9I. Without any change to the zoning of the Waipopo land to Māori natural hazard provisions and the servicing provisions in the Māori purpose zone chapter to recognise the special situation at Waipopo and Te Kotari, this will result in the various Crown apologies and well-meant statements from local authorities falling short of the much-needed regulatory change to enable Waipopo Trust and Te Kotari to realise the vision for their land. Thank you again for the opportunity to present my evidence, and I am happy to address any questions.
Thank you. I'll start around the team.
Good afternoon, Ms Stevenson. It is Ms Stevenson, isn't it? Thank you. Thank you for your submission. I enjoyed reading the history of that area. The background to that area is really interesting. Can you not get a bigger water tank than a 30,000 water tank, a 30,000 litre water tank? Is that the largest single tank you can get for holding water?
You could probably get bigger than that, but I don't think it's a requirement for us. I think that's for each block, isn't it? Is it? Yeah.
So to have a 45,000 litre, you'd need to get two 30,000 litre tanks?
No, I think that's a requirement of the plan that you have to have a 45. It was initially 45,000.
Yeah, no, I'm not asking. I know what the plan's saying. I want to know, can you purchase a tank larger than 30,000
I believe
litres?
so, yes.
Okay. I have no further questions. Thank you.
Kia ora kōrua. Yes, like my colleague said, really interesting submission, lots of information, and what an interesting time that we're actually here talking about how treaty principles actually play out in this particular environment. So, fascinating.
Thank you.
So in terms of my understanding of the evidence that you've presented, I want to try and get an understanding of who lives in these settlements, and is it all Kati Huriapa people, or is it or is it a mixture? Who's there?
Currently, the properties that we have down there are rented, and there is a mixture of Māori and Pākehā living in these homes. They're not at market rents. We've renovated them and brought them up to compliance. The home compliance, the regulations for compliance for them to live in there. Healthy home standards have been completed, and so that's in there. We do have quite a number of owners in the property in these blocks. There's been no dividends paid for years. When I came on to the trust, it was completely run down. It hadn't been maintained, and it's been an upheaval battle to get them to where they are now. So, yeah.
And so my understanding of a lot of settlement areas, quite often the trust may own the underlying land, and then the structure above is often owned by sometimes the occupier.
Anybody else.
Yeah, so what's your position?
Initially, Waipopo was that the land was owned by the trust and the homes were owned by private owners. And mostly that was fishermen, like batches. It changed in 2012, I believe, that went to court because there was a dispute when the rates for the lease of the land, there was a dispute between the owners of the homes and the trust at that time, and it eventually went to court, and the court determined that all the houses would be owned by the trust. So that's how we've come to own these houses. Unfortunately, the trust never maintained them. Naturally, the people that owned the houses took everything that they could and left the homes. And I would think probably the money was short, and the homes weren't maintained to what they are today. However, they did lease the properties out that were able to, and then and that's how it's been. The kōtare is just land-based. Like, we own the land, but the houses are owned by the people. So that's the difference between the two.
No, that's really helpful to understand, because my next question was trying to understand how the peppercorn lease came to an end, but I think you've just answered that. Would have that been through that same process? Mm-hmm. Okay, thank you. And my other question's really probably more directed at the water expert, because I'm trying to understand what the risks are with the stop bank. So thank you for your evidence. I just scroll down. No, I have no further questions. Thank you.
Thank you.
Kia ora, Ms Stevenson. Just one question I have for you. It's a bit of a detail around the concerns around the cost of the different tanks. And I was wondering what the cost differential was that you had calculated, well, approximately, between having to go down a 45,000 litre requirement as compared to a 30,000 litre requirement. What was kind of the cost differential between those? Obviously significant, am I assuming correctly there?
I'll get Shona to answer that.
Thank you.
Sure. So we had the Davis Ogilvy prepared the Three Waters assessment, and in that report they provided a cost estimate for the 30,000 litre, and that was considered sufficient. So they didn't investigate anything beyond that, because they anticipated that would be enough.
I see. So, and in turn, the trust has determined that anything beyond that cost would be untenable.
Yeah, most likely.
Yeah. Okay. Thank you.
Thank you, Ms Stevenson. I have no further questions for you. Again, just to compliment you on the level of detail that was provided with the evidence and the appendices. That's been most helpful. So, thank you.
The second witness is Robert Kerr, and Mr Kerr has prepared a summary of his evidence, and if it pleases the Madam Chair, he will speak to that summary.
Please, welcome. We have you online. please just take us briefly through your summary statement and then we may have questions for you. Thank you.
Okay, thank you very much, and do wave at me if you can't hear very well. So my full name is Robert Kerr. My qualifications and experience are set out in my main evidence, but the summary will set out my key points from my evidence in chief. So my evidence assesses the flood hazard to the Waipopo huts from a breach of the Ōpāhi River stop banks. In summary, I'm concerned that the assessments undertaken by Environment Canterbury are overly conservative, and that leads to an actual flood hazard being overstated. And the actual hazard is not likely to meet the threshold of a high hazard under the Canterbury Regional Policy Statement. The key point here is that there is uncertainty in the robustness of the hazard assessment of the Waipopo huts. In my view, the likelihood of a high hazard across the site is materially lower than that assessed by Environment Canterbury. However, while maintaining a prudent approach to flood hazard, I suggest that this uncertainty needs to be considered in the light of the competing matters, such as those raised in the evidence of Ms Stevenson regarding Kemp's deed and the history of the site, and the duties of local authorities in relation to Te Tiriti. That said, I consider it as prudent to manage future development in the area so not to materially increase the impact of any flooding on people and property at the huts. As such, I'm able to support an approach where the lower lying areas closest to the stop bank retain a form of existing use rights, but are limited as to the ability to develop, with the high areas able to build modern homes subject to compliance with finished 4-level requirements. That's a summary of my evidence, and I'm happy to address any questions that you may have.
No questions for you, Mr Kerr. Everything's very clear to me. So, yeah, no remaining residual queries from me.
I have one question, and I'm trying to find its location in your report. I know that Ms Stevenson has also referred to it in her evidence, which says that the stop bank in its current position creates a potentially significant flood hazard risk. And it seems to be that the works previously done is causing more of a risk. Have I understood that correctly?
So I would explain it more like this, and this will be in sort of 2 points. One is the existence of a stop bank alongside the river, alongside the whole of the river, not just outside where the huts are, creates a greater flood risk for the huts, because if the stop bank wasn't there at all, it would during a flood it would come out of the river channel further upstream, and as has been shown by the modelling and history, it doesn't come through the hut site. But probably more relevant to your question, simply if there was a breach immediately adjacent to the buildings, then clearly the water would go through and around the buildings, and so therefore that would be in terms of consequence rather than likelihood, that would be a significant impact.
Okay, thank you for that. So, what would the point of the stop bank be? Wasn't the stop bank put in place for flood mitigation?
The stop bank is in place, but is alongside both sides of the Ōpāhi River, right up to Fairley or wherever, I can't remember exactly where it ends. So it's much greater than simply for the settlement.
Thank you.
Yes, good afternoon, Mr Kerr. At your paragraph 27.1, you say the river has not historically breached in this location and previous floods are known to have not affected the huts. Can you please clarify, because the ECAN report figures 4 to 15 shows breakout flow locations near the huts and particularly two breaches close by. Now, the picture I'm looking at is figure 4.15. 4-15.
Yeah, these, I've got this in front of me. That's the modelled locations. So that's assumed locations rather than actual historical locations of breakout.
Okay, and I didn't read that. But no doubt you're right. So you've obviously looked at the photos in the ECAN report. It shows quite severe flooding, and I'm wondering, because these photos were taken, one photo I'm looking at was taken in 1951, and there's a few photos that show quite a bit of flooding. And it looks like, I can't tell whether it's up to the huts or not, but it's certainly all around the huts.
Yeah, so I've in the examination I've taken of those photographs, it hasn't been actually around the huts. Yeah, you're absolutely correct. In that general areas, there's plenty of water. How deep it is another question, of course, and you can't tell that from the photographs. And with the high hazard definition of over a metre, that's a reasonably important point. But you're right, there is the potential for water, and we've seen water go in that general area. But from the evidence that I've seen, I haven't seen anything that suggests that it's actually gone around the huts or through the huts, and certainly been up to that sort of metre deep either.
Okay, well, the other one thing I'm trying to understand is the 20% versus 10% add-on that they estimate. You know what I'm talking about. I don't know quite the right words to use, but I'm referring to the ECAN report.
Yeah, I think I know what you're referring to. So the question is, under the regional policy statement, we have a threshold of 1 in 500 or 0.2% annual exceedance probability.
That's right.
That's an event is a combination of, one, the likelihood of the rainfall occurring, and so therefore two, generating the flows in the river, and then three, it breaking out in a location which causes the water to flow through the huts. So it's a combination of probabilities which all need to then be within a 1 in 500 year event or 0.2% event in order to meet that threshold in the policy statement. So the 20% likelihood that has been assumed by Environment Canterbury staff there is the likelihood of it breaching in a location
near the
immediately
railway
adjacent to the huts.
Oh, you're talking about the State Highway 1 railway, for example.
For example, so there's roughly between the coast and State Highway 1 around about 7 kilometres. So that on both sides, that means 14 kilometres of stop bank. It's pretty likely to break out at the one of the two bridges or both bridges because of the nature of bridges and abutments and so on. So the likelihood of it breaking out elsewhere is obviously less and likely to be an equal regardless of which bit of stop bank, which kilometre of stop bank. And if I had a whiteboard, it'd be easier to explain, but hopefully it gives you an idea that the likelihood of it breaking out at this particular location combined with the flood event is a lower likelihood than simply just the flood event itself.
And because I'm not an engineer, the weak points and stop banks, are they around culverts and bridges and places like that?
So there's bends, particularly sharp bends, but also culverts or bridges, but also there is weak points and stop banks that we don't know exist because they're weaker because they weren't as built as well as the adjacent part of the stop bank. Or there are particular formations underneath in the bed of the river which for just a matter of chance, direct the water in a certain way that undermines a stop bank. So there's multiple ways in which a weakness in a stop bank can develop.
Okay. At your paragraph 27 of your EIC, why do you consider it to be less than 10% chance?
Sorry, why do I consider it to be less than? Yes. So we have two stop banks, one on either side of the river. So therefore on the south side of the river, that's a 50% chance because they're roughly even. It's a higher chance that there will be a breach up at the State Highway 1 bridge or the rail bridge. So that takes another significant portion of that 50% out of the equation. And then we have another 7 kilometres of stop bank between the bridge and the coast. And say if we split it up into half 500 metre long sections, then we're getting about a 3% chance, maybe a 2% chance in each of those 500 metre long sections that there would be a breach.
Okay.
So that's as far as I've taken my analysis. To do a graded level of analysis requires multiple skills and multiple people around the table, but that gives you an idea of why I think that a 20% assumption is too conservative.
Okay. And just to clarify, flooding from a river is caused by either an overflow of the bank, the stop bank, or by a breach in the stop bank. Is that right?
That's correct. What typically happens is that it starts to overtop the bank or get close to overtopping the bank, and it finds a weakness somewhere and starts to scour out the bank. So an overtopping usually leads to a breach.
Okay, thank you very much. Thank you very much, Mr. Kerr.
Pleasure.
I have no additional questions for you. Thank you very much for your evidence.
Okay, unless there are any further questions for me or Ms Stevenson, then that concludes the case for Waipopo.
Thank you very much, Ms Walter. I just should also note on the record that the panel, during the course of the hearings that we've had over the last 6 months or so, have undertaken a number of site visits, mostly just in terms of a general orientation around the district, so particularly those panel members who reside out of the Timaru district are familiar with the sites and locations that are being discussed, and we did visit Waipopo Road area and the settlements there and observed a number of the dwellings from the road area. So we're familiar with that area, so thank you.
Okay, thank you very much.
Online we have Enviro New Zealand. Ms Rosser is joining us by video link.
Sorry, Mike. Can you hear me?
We can hear you, can't see you.
Yes, for some reason it's gone very blank. Sorry about that. Let me see if I can fix that. Oops, hang on, I just took this camera off. Oh, dear.
Technology is great, isn't it?
Yes, I know, it's great. You can see my chin. I'm not sure how this occurs. Tilt it a little bit. try that. Very sorry about this. There we go. Okay. Good afternoon. Oh, sorry, we've lost me again. There we go. No, why isn't it doing that? I'm sorry. Okay, we'll just leave it like that. Hope that it'll behave itself. I'm sorry. Good afternoon. My name is Karen Rosser, and I appear on behalf of Submitter 162 EnviroNZ. My qualifications and experience are provided at Appendix 1 of my evidence. EnviroNZ submitted on the proposed plan on a variety of matters regarding solid waste management, and in respect of this particular hearing stream, it was the issue of the definition of regionally significant infrastructure. So EnviroNZ is the operator of the Redruth landfill site, which incorporates Class 1 landfill along with a materials recovery facility, a refuse transfer station, an organics composting facility, and a regional office. There's also a reuse store on site called the Crow's Nest, run by the Sustainable South Canterbury Trust. And Mr. Willis has recommended in the Section 42A report that this facility is recognised as a regionally significant infrastructure. I agree with that, and that's the reason I'm here to speak to that today. As a Class 1 landfill, the landfill has capacity until approximately 2050, so it's a rather long-lived facility. It takes material from the surrounding region, including the Mackenzie district. The annual tonnage in 2024 that went to the landfill was approximately 32,000 tonnes. If the landfill was not available, this tonnage would have to go to one of the other Class 1 landfills, which are few and far between in the South Island. So that would be either Kate Valley, that's 3 hours to the north, Green Island and Dunedin, almost 3 hours to the south, or Gibbston Valley near Queenstown, again, sort of 3 hours to the southwest. As you can see, that I guess demonstrates that the landfill services the whole of the South Canterbury area, and therefore I think it's of strategic importance to the area. The facility at Redruth also processes 28,000 tonnes of organic material annually in the composting plant. It recycles 10,000 tonnes of recyclables and 2,500 tonnes of glass. It also takes reusable goods and household quantities of hazardous waste. So these facilities are important to divert material from the landfill and help to meet the emissions reduction goals. And this will help with realising the whole of the operational life of the landfill. Obviously, the more materials you divert, the longer your landfill will last. By evidence detailed that being recognised as regionally strategic infrastructure would accord with the New Zealand Waste Strategy and the New Zealand Infrastructure Strategy. And the New Zealand Infrastructure Strategy refers to infrastructure as fixed, long-lived infrastructures that facilitate economic performance and well-being. And it categorises waste as economic infrastructure. And the strategy particularly focuses on waste as it has one of its 5 objectives as being to move to a circular economy. And therefore, I think it being defined as regionally significant infrastructure was certainly aligned with that objective. The New Zealand Waste Strategy obviously focuses on waste management infrastructure being in place to achieve a circular economy. And it notes at priority 2.2 that waste management facilities and services have not always been included in lists of essential infrastructure. And I certainly know in my work that this is the case throughout the country, and it's slowly, I guess, being recognised in that sense. Obviously, we viewed in COVID-19 lockdowns that waste management services and facilities still had to operate, and they definitely were essential during that time. So I've reviewed the Canterbury Regional Policy Statement, as I'm certain that you must not only you must have regard to that in relation to the proposed plan, and consider that if the landfill facility was viewed as regionally significant infrastructure, it doesn't conflict with the objectives and policies in the Regional Policy Statement. While it's not defined under that statement, I do note that there are many other plans where landfills, regional landfills, are defined as regionally significant infrastructure, and that includes the Natural Resources Plan in Wellington and the Northern Regional Plan. Obviously, it's very difficult to consent a new Class 1 landfill. Certainly the Dome Valley application north of Auckland has demonstrated this point. And by acknowledging the landfill, and I agree with Mr. Willis that this allows for the landfill to be recognised for its strategic importance and its continued operation and development. I guess the only other point to make is that this may have implications with the parts of our evidence in relation to the strategic objectives chapter of the plan. So I suggest that I appended my evidence for hearing 1 in this to this evidence, and it will see, you'll see where this may have consequential amendments may be required, or just not so much amendments, so just taking a review of that evidence at the same time. Open to any questions?
Thank you, Ms. Rosser. Just noting that, yes, we do recall your evidence from Hearing A, and also that the panel did undertake a site visit of the Redruth landfill facility following that Hearing A as well. So we're aware of the particular activities and proposed development that's occurring within its bounds at the moment. I'll now just hand over to questions. I'll start with you, Commissioner White.
Good afternoon. I'd just like to ask initially, were you online listening to the questioning to Mr. Willis at the start of this hearing?
No, unfortunately, I wasn't able to attend that.
Right. So there's probably some questioning. There was some direct questioning of Mr. Willis from some members of the panel around that. So some of the matters had been, I know, questioned with you at Hearing A around and it was around RMA definition of infrastructure versus the wide variety of ones, those documents you've referred to us again today. the question that was posed to Mr. Willis was there a way of providing for the activity that you're seeking other than in the infrastructure chapter? That then meant it could just be directly provided for in a relevant place where all the rules and all the provisions kind of sat. And I think Mr. Willis's response was that it could be done through potentially the zone provisions. And he was asked whether he had...
What, sorry, revisions?
The relevant zone provisions. I'll just finish. If I just finish saying what Mr. Willis was questioned and answered,
Yes.
and then I'll ask for your views. So he said that could be an answer, a response, and then he was asked what his preference would be, and because he had told us it was quite a fine balance for him in terms of reaching the view in his Section 42A report, and he said his preference might be to deal with it in a different location than the infrastructure. So I just wanted to bring you up to date with where that questioning had got and probably seek your views, if you have some views on what that line of questioning may have drawn out.
Yes, would have been nice to have reviewed that. I do still think it's relevant. I still think, the landfill facility is infrastructure per se, and therefore I think it's certainly helpful to have the benefit of the objectives and policies of the infrastructure chapter, and also obviously the infrastructure section of the strategic objectives for the district. And the reason for that is because there are no policies or objectives that do not apply in relation to the facility. It's often subject to reverse sensitivity. You do need to manage its effects, but it is obviously required for the functioning of society. So I guess that's my view on that. If it was dealt with in the general industry zone, it becomes a specific activity there that you're not able to differentiate it from other activities in that zone without some sort of precinct. Or which obviously we did not go forward with that at this point. But I do think it has specific qualities and it's of significant importance to the district that it should be recognised in some manner. And I think it will be sufficient to have the advantage of being recognised as regionally significant infrastructure, because the main issue I can see is obviously encroachment for its future operation, and therefore particularly plan changes will have to consider the impact of those plan changes on regionally significant infrastructure. And I think that's a valuable tool.
Okay, thank you for that. Just one other thing I want to consider is there was quite a lot of discussion and come through this hearing in particular about any relativity between the the infrastructure chapter and other chapters, and in particular zone provisions. And I just want to know, have you given any thought to how, because as I understand the way the provisions are drafted, what you're seeking to rely on is objectives and policies in the infrastructure chapter, but that rules or consent requirements aren't actually in the infrastructure chapter, they're somewhere else. And I just want to know, have you given some consideration to the various views that might have been expressed around which chapters should take prevalence and whether there's a particular issue that needs to be responded to in relation to the activity you're concerned about?
I reviewed the chapter in terms of how it would apply if it was just the objectives and policies, and certainly that was my original preference, was to put an additional sentence at the beginning so that it's to state that the rules will not apply. Obviously, it's a designated site, so that's where it will. The rules applying to that will be apply in relation to the site in most circumstances.
So then, just on that, so can I clarify? Is the key issue you're concerned about, given that your site in particular is going to be subject, in terms of the designation, is the key issue that you're quite concerned about in relation to the infrastructure chapter, is it really around reverse sensitivity, or is this something else?
I guess that is one of the key issues. It is reverse sensitivity, and the fact that those objectives and policies, there are obviously some specific to other types of infrastructure, but the general ones are certainly applicable and would help determine, like I said, any plan changes coming through which need to have regard to infrastructure. And it would not necessarily have that regard without the being defined as I propose. So, as a designated site, it certainly is able to operate under that designation, but it won't always have that reverse sensitivity looked at for neighbouring plan changes, etc.
Okay, thank you, that's helpful. That's all the questions I have.
Commissioner Scott. Thank you, Ms. Ross. There's no further questions from the panel, but I was just, if the panel reached the view, and I think it's fair to put on the table that we have a level of discomfort around shoehorning this facility into the definitions which are prescribed under the Act and in the regional policy statement. And if our preference was the alternative that we put to Mr. Willis, that there was somehow a bespoke set of provisions that applied within the correct zone that obviously addressed the existence of the designation as well, would you be open to working with Mr. Willis to formulate what those provisions could look like?
Yes, certainly. Yeah.
Okay. Thank you very much for your submission.
Thank you.
Submitters Peter and Stephanie McCulloch. Are they joining us by video link or? Great, thank you. Welcome.
Hello, I'm submitter 137.
You are.
And firstly, I'd like to introduce myself. My name is Stephanie and I speak on behalf of myself and husband Peter about the SNARs and the SASMs that have been included in the TDC district plan. A bit about ourselves, we both have a very strong connection with this area, with my great-grandmother having run the local maternity hospital and my grandmother teaching at the local marae. My relatives' names feature on roads, sports fields, church plaques, the Temuka Borough Council and the cenotaph. My husband's family has been on this land that we call home and love since buying it in 1866. Certainly his forebears would have been there prior to this, as this was the purchase date on the title deeds. His grandmother was renowned for taking the horse and trap to visit the locals, both in Temuka and at the local marae, with food, clothing, and to welcome the new babies in the district. We both like to think of people as a suitcase, It doesn't matter what they look like, what colour, shape, or how many dints they have. It's what is on the inside that matters. We are not racist and respect others and expect the same from them, but I do not see this happening in this. To say that the consultation process was a shock to us is putting it mildly. We had absolutely no idea that we had anything on our land that could be even regarded as a SASM or a SNAR. We found the submission process very hard to navigate as we're both a bit technologically challenged. And Sendas's submission in as a written statement on the 7th of December and received it back on the 13th, as it would not be accepted unless it was on a special template. The length of time involved in this process has been over 2 years, and that's also been quite hard. Now, I'll read out my submission that we sent in. We are writing regarding the blanket claim of the Hei to Mona River and land beside it. This has been done without any consultation. Nobody had any idea that was going to be in the district plan. As private landowners with land that is involved in the SASMs and also with existing AMF rights, we have legal sovereign rights. The generic letter dated the 20th of October 2022 informed us that submissions closed the 15th of December 2022. We then wrote here regarding this on the 2nd of the 11th with no response to our question. By definition in the Black's Law Dictionary, any act is a contract requiring agreement by both parties, and we do not consent to this application of a SASM on our property. Our family have farmed this private property for over 150 years and have a strong spiritual and physical connection to this land. Our forebears and ourselves have nurtured this land and wish to continue with this guardianship for the future generations. We find it hard to see how by attempting to usurp our ownership and restrict our activities on land that we've worked to maintain is fair and equitable. Black's Law Dictionary, 2nd edition, just, fair and right in consideration of the facts and circumstances of the individual case. We now also are uncertain that shelterbouts planted under our care with natives and cabbage trees may be designated as an SNA in the next 10-year plan. Meeting with federated farmers, the TDC was not able to confirm that this would not happen in writing. Under contract law, full disclosure must be given in any contract. In this instant, with regard to the recent TDC letter dated the 20th of the 10th, 22, the local Runanga refused to give information about the SASMs on the grounds that it is not appropriate for the cultural heritage associated with the site to be questioned by those who do not have the expertise or authority to comment in regard to this or any property in the Timaru District Council catchment that have SASMs, SNARs imposed on them. This non-disclosure deems any contract null and void. Furthermore, in your letter dated the 20th of October 2022, it stated that certain rules in the proposed district plan now have mandatory immediate illegal effect. This includes rules in relation to water, air, soil conservation, significant natural areas and historic heritage, including SASMs. Does this mean that the Timaru District Council now wishes to be a conservator of our land and the areas claimed under the SNA's, SASMs and significant wetlands? The Black's Law Dictionary 10th edition states the legal definition of mandatory is demanding compliance. You need consent for compliance. A mandate is not law. So now I'll carry on with this. As you will all be aware, as part of the ACT National Coalition Agreement, the government committed to ceasing the implementation of new SNARs. This is now being carried out as part of the government's RMA reforms. These SNARs caused a lot of angst amongst people with cabbage trees and flaxes, which had been planted by the landowners, including us, because they were natives for shelterbout protection. And the reason they planted natives is because they value them. The landowners then began removing these because councils such as the TDC could or would not guarantee when asked directly that these would not be included as a SNAR in the next 10-year plan. This was very sad to see this happening, but now we at least have a 3-year window with these being reviewed. As you've heard in this submission, we have AMF rights to the Hei Hei Timona. There is no Queen's Chain along this river, and the TDC has no right over this land. They do no maintenance, but we are unsure if they still claim a royalty from gravel extraction. So what does this ancient title mean? It means this land cannot be claimed or removed from our ownership. It is ours. We have both a written and oral language of events that have occurred over the years, and this has been handed down through the generations. I wonder how many people sitting in the room you are now have walked up the Hei Hei Timona within the last 2 months. And I don't mean going to the Timona Gorge, because the river is not just the glamorous spots, it's the whole length and entirety. And remember that it's a semi-legal proceeding and the information you give has to be honest. And again, what about the Waihi? We go down every week and enjoy the environs as we go about our work on the farm. We've swam in the river, walked parts of it that are included in our farm at least 3 times this year, 2025 already. Over the years, we've fished in it, canoed in it, and generally enjoyed it. We've monitored it at its extremes, both high and low, and it has always been there as part of our farm and our life. For these areas to be considered SASM, it's amazing that this area is not being visited more by the people that consider it sacred. I have not seen anybody, rather than us, trying to remove the old man's bed that has sped through the riverbed and encroached onto the neighbouring riverbanks. Stock is kept completely out of the river bed except for the unexplained breakouts that occur very occasionally. We try and control possum and rabbit numbers and keep hemlock and buddleia, which has been dumped as garden waste, and other noxious weeds at bay along there. In other words, we care for it. I was extremely annoyed to read in the letter dated the 30th of June 2021 from the local Runanga, John Henry, cultural consultant at Aoraki Environmental Consultancy Limited, to the senior planner, Alex Wakefield, Timaru District Council. This stated, and as per our submission, I quote, that they considered...
Ms McCulloch, just so that you know, we have a copy of that letter and it's been referred to several times in evidence, so you don't need to read out any excerpts from it.
I've got this short bit written about they considered it as not appropriate for the cultural heritage to be questioned. How can people be expected to respect something if they don't know what they are respecting? This behaviour is not inclusive and certainly does not treat people as equals, and is derogatory and disrespectful to their intellectually acumen and principles. It is also interesting to note that on page 3 of the same document, and I quote, Arawhenua do not support the repairing of existing large-scale infrastructure following a natural event that damages domestic and farming-related infrastructure, tracks, driveways, drains, water storage ponds, dams, fence lines, pipelines and irrigation as a permitted activity if this requires extensive earthworks or infrastructure to be relocated or positioned. An example of this would be relocating a water storage pond due to a flooded river cutting into it and eroding the banks supporting a storage pond. Whilst Arawhenua and AEC accept there is a need to repair potholes, redig fence posts and stabilise a very minor slip, a scale of works needs to be ascertained to prevent landowners undertaking the work on their own without input from suitably qualified experts. A permitted activity status also prevents Arawhenua from having any input into an area that is of most importance to them. Well, believe me, we had a hydrologist from the TDC telling us that water ran uphill by itself. So just because you have a degree does not mean that you have common sense and can apply your knowledge in the correct manner. When the 1986 flood struck struck, doing so much damage both around this area and Pleasant Point. Who helped with the big clean-up then? Federated farmers were fantastic, but it was the landowners who had to pick up animals' bodies and bury them, mend fences, clear the huge trees that had smashed everything in their path. Who made repairs to the stock banks? No experts came to help us or advise us because we had to get on and do these things. We all did what we had to do to make our land whole and special again. Having land belonging to us that is now into its 7th generation of ownership, we too have SASMs on this land that is special areas of significance to McCullochs. These include places where stillborn babies have been laid to rest. So when you cannot be told why an area is important to others, when we ourselves have our own SASMs, I know what would take precedence in our eyes. At one of the several meetings regarding the introduction of the SNARs and SASMs that I attended, one farmer was particularly bemused when he saw the line marking the SASM go up his river boundary, then jump out over the stock bank to include his 4 hectares of poplar trees, then go back to the river. Poplars are not native, and this person had planted them himself, as we also have. And if the area of land on either side is taken, then this includes all the trees that people have planted.
Mrs McCulloch, can I pause you there? You refer, no land has been taken in relation to this. This is simply a plan process where there are overlays that have been identified on your land in response to national direction in terms of the national planning standards. What we are doing through this process is trying to understand what the consequences of the provisions are and whether or not the rules are appropriate. What we're really interested in hearing from you about is how the proposed rules in the notified plan and as recommended to be changed by council reporting officers impact on your farming activities. So whilst we completely respect your own associations with the land, that is not in question here. We're trying to focus on the provisions in the plan. So if you can help us understand how you are impacted by the rules proposed in the plan, that would make your submission much easier to understand from our perspective.
So are you saying that this SASM will have absolutely no impact on what we can do or not? And that's what I'm trying to point out to you, because in our opinion it will.
You're not listening to me. Quite clearly, the provisions in the plan will have an impact on activities that can occur on land, just like any rule in the district plan has an impact on what people can do on land that they own. We're trying to ascertain whether or not what's proposed is appropriate, and therefore we have to consider the cultural values that have been identified, but we also have to consider how they impact on your farming activities. And so our focus is on the provisions in the plan itself, rather than what we're hearing from you about what you may have heard in relation to other landowners and the like. So could you focus on the proposed plan and explain to us?
Well, my question is, how can you comment and say how it will affect you when you don't know what it is?
So, okay, well that puts us in the right place for a dialogue. So you're not understanding what the impact on you will be from the identification of part of your land as a site of significant, or an area of significance to Māori, and the significant natural areas.
No, what I want to know, and it's never been stated, and as per John Henry, we aren't entitled to know why that area is sacred, where exactly it is. So how can you claim whole lengths of rivers and not be entitled to know why?
Okay, so can you tell us what the number is of the significant...
Have you not got it there?
It's not in front of me immediately. Can you tell me, I know your submitter number, but do you know what?
SASM 20, which says no defensive works, but steepness and defensive position and a few terraces in defendable weak areas. Main feature is large bank flat platform, 30 metres by 20 metres.
Right, okay.
Now, if this process goes ahead and takes so much land on either side of the river, which I don't see how they can when we have AMF rights out to the middle.
And again, nobody is taking your land. This is simply the identification of an overlay that has been identified by Mana Whenua as containing matters that are of value to them. And that is a process which is provided for in the National Planning Standards. And we need to now go through a process of evaluating that information and the points that you have raised in your submission and determining whether or not it is appropriate to have a requirement for additional resource consents that may apply within those areas. This is not a taking of land.
It is an altering of our rights to the land and what we can do. So that is a sort of taking, if you can understand. What I cannot believe is the fact that we have got, as I said, a lot of oral and written history. We don't see people coming up and down the river. We are out there a lot. If this is so sacred, why are they not there? Why are they not helping clean up and do all that kind of thing? You know, if this is so sacred. History states that the Patipai Ārihi were the first people to inhabit this land prior to the Moriori and Maori. They were very peaceable, red-headed white people descended from Persia before coming to this land that they called the far-off land. Arriving over 1,000 years ago, these people travelled by boat and lived off the land. With the historical finding of stone carvings, carved stone walls metres deep in the ground, above the ground in the Kaimanawas, scientists believe these are the work of ancient people. And what happens, we're giving all these rights away here, but these people were massacred in their thousands by the Maori, so they're going to come back.
I'm going to stop you. I'm going to stop you right there because this is not the purpose of this hearing. We are focused on the relevant provisions in the proposed Timaru District Plan. It's a public process. We are hearing the views of a range of people and we are focused on the proposed regulation in the Timaru District Plan. If you don't have anything further to add to that, I think we'll end your presentation there. You've used up your 10 minutes and we have other submitters
I had 15 minutes allocated.
So, I'm sorry.
I had 15 minutes allocated.
I'm sorry, but we're over time. So if you would like to make
I just want to say that I had this 15 minutes allocated and I should be entitled because what happens if we give away all this, allocate all this SASMs and everything, and then people come in the future and want it taken back?
No, this process is about
our land use.
I'm sorry, Mrs. McCulloch. I'm sorry, that is the end of your presentation today. We have your written submission. Thank you for your time. We now move on to the next submitter.
Rude, actually.
Okay. Our next submitter is Millwood Finlay Lobb, and we have Melissa McMullen.
I would like to start by thanking the hearings panel for allowing me to provide my evidence statement late due to my recent illness. I apologise for any issue that this may have caused to other submitters and the Section 42A report writers, as well as the hearings panel. Today I will be providing additional comment on the submissions that Millwood Finlay Lob made on matters that are dealt with in hearing E. I do provide additional comment on matters not addressed in my evidence statement, and I'll provide a copy of these speaking notes to the hearings administrator for the convenience of the panel. My apologies, this was not addressed in my evidence statement. It took me slightly longer to recover than I had anticipated. First of all, I accept that the boundary adjustment definition will need to follow the national planning standards, and I'm comfortable with accepting the Section 42A report writer's recommendation. Moving into the various rules that we commented on, for energy and infrastructure, Rule 8, the parameters that are set for substations were top of mind at the time of submissions, as we were working with Alpine Energy Limited to help design and obtain consent for a significant upgrade to the infrastructure in Washdyke. I provided a copy of those plans to you today to give you an idea of the scale that we're working on. I appreciate that it is difficult where Alpine Energy have not submitted on this matter themselves. However, I have been in discussions with Alpine about this, and if there's any interest in reviewing the rule parameters, it would be much appreciated if this could be entertained. So yes, you've got a copy. Those are the consented resource consent plans that you've got there with you now. And so this shows what's typically built on a substation site. So there's transformers, a switch room, and associated infrastructure. But I would draw to the...
Madam Chair, may I just make a question of clarification? Thank you, Ms McMillan. Can I just check with you, so your evidence statement relates to MFL submission points?
Yes.
Right, so that's the evidence statement we have in front of us?
Yes.
However, this relates to the submission of Alpine.
No, Millwood Finlay Lob submitted on Rule 8.
Yes.
As that was part of our submission process. We didn't have any conversation with Alpine at that time because we were all sort of a bit silent. It was a bit of a crazy time. But we have since been in discussions with Alpine Energy because we do work with them for the consenting and that sort of stuff.
Right. Yeah. And so you're presenting this to us today in support of their submission? Or just as evidence?
So that relates to our submission points.
Okay,
so, yeah.
Thank you.
Yeah, sorry for the confusion. Yes, appreciate it. So yeah, I would also just finally add to that point that substations primarily actually have above ground lines. This Washdyke substation was an exception with having its cabling underground. Moving on to Rule 39 for the Energy and Infrastructure chapter. So we proposed a wording change, and that was the addition of the wording certification from a licensed cadastral surveyor. This is suggested to provide council with an assurance that the district plan has been complied with. The provision of the certification of height will remove the need for unnecessary consents from the Timaru District Council and will simplify the process. Moving on to the various stormwater management matters. As mentioned in my evidence, I'm aware there are proposed changes to the stormwater management rules. We are happy to work together with the council and other submitters on finding a path forward for these rules. I would note that our engineering department have been working through different scenarios where and what this shows is where the attenuation tank required. It would be of a large and impractical size on the site. So it has been explained to me by our engineering team that the key is to limit the discharge to being less than 1 litre per second, which requires a large surface area because the more depth that is within an attenuation tank, the faster the water will exit the site, which will then breach the 1 litre per second requirement. I can provide more detail from our engineers to the panel if this would be helpful. However, I appreciate that it is more likely appropriate for this conversation to continue with the council and various affected submitters. We would be very keen to be part of that discussion. Moving into the sites and areas of significance to Māori chapter, particularly Rule 7. As discussed in my evidence, the primary reason we have asked for a restricted discretionary activity status is so that the matter is treated consistently with other overlays throughout the district plan. I note discussions you had with council officers yesterday morning in relation to how consultation with mana whenua is carried out at the moment, and I note that the relief we are seeking would most likely require the applicant and us as agent to go and carry out the pre-application consultation. This would reflect how we currently work with various other parties, such as the New Zealand Transport Agency, Alpine Energy and Meridian, for example. I appreciate there is a question that has been put to council about the process that is undertaken, particularly with regard to consultation, and we as a consultancy are happy to work with whatever system the council wish to utilise. The other concern I have with the rule status being discretionary for subdivision activities is that a site, particularly in the rural context, may have an overlay. However, this could be far removed from the subdivision activity, and therefore it would be difficult to argue that there is an impact on the site and area of significance to Māori area through the subdivision. I'd also like to draw further attention to the different activity statuses that have been allocated to different activities within the sites and areas of significance to Māori chapter. In my mind, a subdivision activity is more benign than the other activities listed that have an impact on the landscape, such as earthworks. I note a correction is required to the activities listed in my original evidence brief to reflect that there are a number of proposed changes that have been suggested by Ms White within the chapter, with the removal of activities such as intensively farmed stock and mining and quarrying activities outside the bed of a river now proposed to be a restricted discretionary activity. There are a number of matters we are seeking changes to in relation to subdivision standard 1. I'll now quickly run through the matters that I want to expand on in more detail. For subdivision standard 1.1, within residential zones in particular, the 15-metre diameter circle is very difficult to achieve, particularly when the circle needs to be clear of vehicle access. It is my understanding that the Timaru District Council prefers to support infill subdivision as part of providing for growth within the district. To have this as a non-complying activity, if that 15-metre circle cannot be met, would be detrimental to providing this infill development. If it would be helpful to the panel, I can provide a number of examples that demonstrate how easy it is to breach the 15-metre diameter circle requirement in the Timaru District. I'll just quickly make a note of that. In relation to the 2 hectare minimum allotment size required in the rural lifestyle zone, I note that this is linked to a wastewater connection not being available to the site. However, there are a number of alternative wastewater solutions that are available that have a permitted activity pathway through the Canterbury Land Regional Plan, namely composting and incinerating toilets. The only discharge that is required is the grey water discharge, which is carried out via dispersal lines and is able to be accommodated within a 5,000 square metre section. I appreciate the allotment size also contributes to the surrounding amenity, but in the case of the rural lifestyle zone, these areas are typically linked to a residential or settlement zone. Therefore, it is appropriate to allow an allotment size that reflects the peri-urban nature of the transition from urban to rural. The Millwood Finlay Lob submission points that relate to the various development areas, so that's submission points 60.49 to 60.56, all request the same change to the wording of the standard, which is the addition of allowing a suitably qualified licensed cadastral surveyor or registered professional surveyor to also be able to design and certify roads and infrastructure. This was requested as it reflects the case that is currently occurring in the district that happens today, where we're able to do that. Finally, I draw the panel's attention to Appendix 10, which relates to the flight protection path areas. Currently, there is no reference to the site control marks and meridional circuits. I provide you a copy of the operative district plan, which shows the additional wording being requested, which is just that wording that sits, I can find it, right piece of paper, and I should have highlighted it, I do apologise. It's just the wording underneath that table referring to the Timaru circuit coordinates of Mount Horrible origin, just because they are different to the New Zealand grid, which would otherwise be utilised. So that concludes the comments I wish to make on our submission points today. Now, happy to answer any questions the panel may have.
Thank you very much for that.
Thank you, Ms McMillan. In terms of the submission point 60.24, that related to the request for a restricted discretionary activity status to apply to subdivisions in the SASM overlay. Can you please just confirm for me whether you're still pursuing that point?
Yes, I am.
Okay.
And yeah, that's elaborated on my evidence.
Yes.
Which was originally sent
Yes.
through. Yeah.
I just thought I may have misunderstood something you said earlier, so I wanted to check that before I went into my questions. Thank you. So, in your evidence in paragraph 5.2, you've quite rightly observed that subdivision is treated differently across the proposed plan. And then in paragraph 5.3, you've focused on the fact that natural character, natural features and landscapes, and sites containing a significant natural area and historic heritage are all rules that require subdivision to be treated as a discretionary activity. And at the end of that paragraph, you agree with that in the sense that you're saying that the overlays that relate to these landscapes should be treated in that way, as a subdivision will be more likely result in a change to the landscape, and this must be carefully considered. So my question to you is, on what's the logic around that? So what are you relying on statutory directions to inform that consideration that those values should be carefully considered in the context of subdivision? So when you say that this must be carefully considered, what informs that planning evaluation?
Comes down to the adverse effects that arise from a subdivision. So I think we can all sit here and logically say that yes, a subdivision will have an impact on the amenity, will have an impact on particularly these areas that have been identified here. They've been identified as being a natural feature and landscape and having natural character for a specific reason. They are being treated at a different level within the plan. And so I guess where I'm coming from with the sites of significance to Māori aspect is that there is a whole different consultation process which would be undertaken with that, which is why it would be treated differently. And as part of that consultation process and as part of the council consent process, we are typically identifying where buildings would be erected and where the changes to the environment would be.
Thank you. And so your understanding of section 6E of the RMA, matters of national importance. So you would place credence in that section in terms of the protection that affords to certain values and those matters that are listed relating to landscape, heritage. Why would the relationship of Māori and their culture and traditions with their ancestral land, water sites, wāhi tapu and other taonga under clause E of section 6, why would that not have equal, why would you not afford the same protection level for those values, given they're all listed in section 6E of the Resource Management Act, which guides the whole planning system and the development of the proposed plan regulations?
Yeah, I can absolutely understand the point being made there, and I don't have a significant counter-argument to that. You are correct, they do need to be given the appropriate, given the appropriate importance. We were just hoping that there would be a way that, it could be managed through the district plan process through if you, show you put in the work and done the consultation and gone through the proper channels and processes, that you'd be able to follow a restricted discretionary pathway rather than giving council that wide ambit to look at everything.
Thank you for that. That's helpful to clarify your point of view there. Thanks.
I have no further question for you. Thank you very much for your evidence. That's been helpful. And also your offer to be involved in any conferencing process that we might direct. So thank you.
Thank you.
Right. I think we do need to get to Mr. Boys. I'm going to suggest the panel takes a slightly early afternoon break now, just for 15 minutes, and then we'll deal with Mr. Boys' report before the final 3 submitters of the day. Thank you. Anything you wanted to add or just further reflect on, let us know. Thank you.
Thank you, Commissioners. So, just to remind, I prepared the Section 42A report in relation to subdivision and development areas and subsequently provided a summary of that report more recently. I'll just go through the summary report. Paragraph 4, I outlined the key issues that were raised in submissions. That was effectively a repetition of the matters that were listed in a table format within the original Section 42A report. I won't run through those, but at paragraph 5, I have listed those that appear to be remain outstanding in respect of the evidence lodged, and they are the activity status of boundary adjustment subdivisions, whether the 2 hectare minimum allotment size for the rural lifestyle zone should be removed, which would default then to a 5,000 square metre minimum allotment size, regardless of whether the allotment is connected to a reticulated wastewater system. The ability to waive esplanade provisions on the basis of the potential operational health and safety requirements of the adjoining land, with the extent of works and contributions required discourages future subdivision development, as it requires too much land to be set aside for esplanade, roading, walkways, cycleways, etc., without any provision for compensation. In addition to those key issues, there were also some other matters raised in the evidence that was received. That relates to whether Development Area 1, Objective 1.11, and Development Area 3, Objective 0110 give effect to the National Policy Statement for Electricity Transmission, Policy 10, and the objectives of the Canberra Regional Policy Statement. That was an issue raised in the evidence of Transpower, Ms McLeod. Consistency of the note that accompanies the development area rules to clarify that the district-wide chapters also apply. Again, that was in the evidence of Transpower. Some land within the Port of Timaru being included within Schedule 12 and therefore excluded from Esplanade Reserve requirements, which was raised in the evidence of Ms Seaton for Prime Port. The addition of the term associational values in subdivision Objective 1 and the deletion of significant threshold therein when considering cultural values, and that was in the evidence of Ms Paul for, on behalf of Trent. And as you've heard from Mr Hull earlier today, whether boundary adjustment provisions should be exempt from Esplanade, and that being made clear in both Policy 7 and Standard 8 of the subdivision chapter, and the requirements and contributions associated with Road 5 shown on the development area plan for Development Area 3. Again, that was an issue addressed by Mr Hull earlier today. In addition, I noted that Ms McMullen's also raised the minimum allotment size for rural lifestyle zone, and that wasn't in her summary, but is an issue that she raised again just now. In terms of corrections to my Section 42A report, Appendix 1 set out various recommended changes to both the subdivision and development area chapters. There were some minor drafting areas in those that I'd like to bring to the panel's attention. The part of those recommendations included bringing across the other subdivision rules and other chapters in the plan and consolidating those within the subdivision chapter, and the title heading for the applicable rule as it relates to sites and areas of significance to Māori was incorrect and didn't include the words "and areas," so I just suggested that that be added. And there was also just a strike through missing in relation to the addition made to Development Area 3, Standard 2, so the change was correctly included within Development Areas 1, 2 and 4, but was incorrectly shown in Development Area 3, and so I've just addressed that at paragraphs 10 and 11, so it's a relatively simple change there. In terms of, well, related to the consolidation of the subdivision rules within a single subdivision chapter, I made some tweaks to the headings for those rules. It could be that some of the wording used there could lead to interpretation queries as to where the rules apply, and that affected subdivision rules 4, 10 and 13. So at paragraph 13 of my summary, I've just included some alternative wording just to remove any potential interpretation issues moving forward. I'm not aware of any other particular issues or errors in the 42A report at this time. So in terms of a list of resolved and outstanding issues, that's set out at Appendix A to my summary report with the orange shading, identifying the areas which remain outstanding, and they are fairly constrained now, I think. I did also have in my summary report some updates to recommendations based on the summaries received. I know typically that would be in a reply report, so in the interest of time, I probably don't need to go through that now. So happy to, it just sort of effectively sets out that I haven't changed my position in relation to those matters that were raised, and just some additional reasoning around that. But I'm sure, having heard the evidence, I can expand on that further again. So I think, moving through my summary report, paragraph 37, I had further consequential amendments required. So I've just set out there a minor change in relation to the Washdyke Industrial Development Area Plan, the fact that the word plan was missing, and again I can deal with that in the reply report. So yeah, I guess the key issue to take from that, the areas outstanding based on the evidence received are fairly confined, and yeah, they're addressed outlined in Appendix 1 there. So happy to answer any questions you have from the panel.
Mr. Boyes, just I might just start. I just had some queries for you around the amendments you're recommending to the objectives and policies around the terminology primary production and intensive primary production. And I just noted in your 42A report that you had stopped short of making an amendment to objective subdivision 1, number 8, which was where the word intensive primary production is used, and I think you said that there were no submissions seeking a change to that, therefore you didn't consider there to be scope. My concern is that you have, however, because of the presence of submissions, gone on to make changes to objective 3 and to one of the policy 5, I think, around reverse sensitivity, and it just appears to create a bit of a interpretive issue, whereas objective 1 is the general objective, and then which is narrower, and then you've broadened it out in relation to the objectives and policy. And I wanted to know whether or not, in your consideration of potential relevant submissions, whether you had considered submissions on the strategic directions chapter and had a conversation with Mr. Willis around his recommended changes to that chapter, and whether somewhere between that and where you've landed there might be some wriggle room to make a similar change to objective 1. So that's my first question.
Yeah, well, thank you for that. I think I raised in both the original 42A report and the summary the difficulty I had with that particular clause within the objectives. It deals with two different aspects, and I think it's problematic that they're both included in the same clause, because I believe the higher order documents have they treat them differently, and that's why I had a conundrum in terms of moving to avoid, because that's not what the regional policy statement says in relation to intensive primary production, but it does go very close to saying that in relation to regionally significant infrastructure. So I think the answer there might be, if we're going to address the scope issue and with some guidance from a panel, to actually split that into two would be my preference. And that would overcome the issue that I raised in the report.
Right.
In terms of the second part, no, I haven't had a discussion with Mr. Willis in
Yeah.
terms of the strategic objective.
It might be worth doing that. The other aspect was after hearing A, I think, or it might have been hearing B, we directed some conferencing amongst different planning witnesses to kind of track or map, I guess in a sense, the concept of reverse sensitivity in the higher order documents. And I wasn't clear whether you had been part of that exercise. I think you said you were aware of it. But again, it might be useful to reflect on that and the conclusions reached there about how particularly the regional policy statement deals with primary production and regionally significant infrastructure within the umbrella of reverse sensitivity.
Well, I guess my response to that is I think it does it differently, and
Yeah.
then hence my preference would be to split that clause into two.
Yeah. So would you split objective 1, number 8 into 2 as well?
Yes.
Yeah.
Yep.
Okay. All right. Well, I won't take that any further. I just encourage some further conversations to happen and perhaps come up with a clearer position. And if Ms. Vila can cast her eye over it and check that there is scope. And also, is it not just a clause 10 consequential change? I mean, if you're going to, they all have to speak to each other.
Yep.
I mean, we have to be, yes, there's legal tests involved, but we do have to be practical around.
Yeah,
We can't have a plan that uses one term in the overarching objective and then in subsequent ones. It's just going to create.
No, I agree. So, no, definitely look into that further and come up with a solution. Thank you.
That was the only thing I had. Panel members.
Thank you, Mr. Boyes. You were present at the start of the hearing where I asked a question of Ms. Bella around paragraph 813, where you were addressing a tension, in your view, when considering the scope of the relief sought, and you referred to the fact that legal submissions may be advanced on that matter. Have you had a chance to reflect on that, and have you got anything to add to our consideration there?
Not at this stage. I guess I can't address the legal question there, but I guess from a planning perspective, I can say that I take a pragmatic approach to the application of both clause 10 and 16 in terms of first schedule and the ability to make changes if it results in a better outcome, better planning outcome, as long as it doesn't result in any natural justice issues or adversely affect any other submitters. So you'll note that my position's probably indicated by the fact that I've gone ahead and made those changes in Appendix 1 so that those development area chapters are consistent, because I think it's beneficial for the plan that they are consistent.
Thank you. That clarifies that. And so essentially you weren't waiting for any legal guidance?
No, I sort of...
Before you made your recommendations?
I inferred it in my report that we would do that, and then that's actually on me that I never followed that up with Ms. Vella. At the time of her legal submission, I was asked whether there was anything else that needed to be included, and I didn't put my hand up at that stage and raise that issue, so that's on me.
No, all good, thank you. At provision development 1R1 per 1, I'll just go to that area. Per 1. Are you at that spot?
Development 1, R1, yep.
Per 1?
Per 1, yes.
So I was interested in the language of it complies with the Browse Gully Residential Development Area Plan. It's probably just, it could be a bit fussy of me to check, but I wanted to understand what exactly is to be complied with. The figure in 21 it's pretty high level conceptual. So is the word complies with accurate? And Elsewhere, I think you've used the phrase "in accordance with." Would that be a more suitable phrase in that instance?
There was some discussion about this very point within the planning group. You'll note that in the policy, I think I've used the words "in general accordance" because the policy ultimately determined that at the policy level that the use of the word "general accordance" was appropriate because it gave that flexibility. But when it come to a rule standard that needed to be more certain, and the use of the term "in general accordance" was a little bit uncertain or a bit subjective, so decided to stick with "complies" in the context of the rule.
And that makes sense to me, absolutely. But if I was thinking about someone interpreting those rules and seeing whether I complied with the development area plan, I'd then go to figure 21, and it's so high level, like there's indicative roads and there's indicative parcels, but really what is it that has to be complied with? What's the focus of the compliance? And in terms of if you were actually checking compliance, what would you be looking at?
Yeah, well, obviously it does put that responsibility or delegate the responsibility to the consenting officer at the time, but typically in relation to a development area plan or an outline plan, they are always a broader précis of the overall development, and the plans that ultimately come in will be more detailed. The key things, if I were in the position of being the consenting officer, I'd be looking for the road layout, the stormwater management areas, the things that are shown on the development area plan. They're obviously the key issues because they were included in the development area plan at this time within the planning document. So it's really checking against those. If the compliance, if you went to the letter, I'm sure you could always find an element of non-compliance because it's almost inevitable, but there will be changes in alignment or location of the roads. But as long as there is a key road within the general vicinity that's of the same standard, i.e. whether it's a collector road or a local road, if there's some fundamental changes to its provision in terms of the roading hierarchy, I would say then it doesn't comply. It's really whether or not it's achieving the same in overall development intentions that's set out in the development area plan, I think is a key way of looking at it.
Thank you. In relation to submitters, the evidence of Mrs. Wharf for the Pains, and we'll be hearing from them later today or tomorrow? Tomorrow. She asserts that the evidential basis for the 2 hectare minimum lot size is unclear, and it looks like she's done a reasonably comprehensive search of the specific 2 hectare measurement there. And in your Section 42A report, you have at paragraph 7127, you've pointed to the Timaru Growth Management Strategy for being the origin of that. Are you able to shed any further light on the genesis of that 2 hectare minimum lot size? Is there anything additional above and beyond that you've described in your Section 42A report?
Nothing in particular. Obviously, the Timaru District Growth Strategy went through a number of iterations. There was a growth assumptions report that was initially done. Then there was a consultation summary and offers of recommendation report that was done, and then the final document that was adopted by the council in 2018. Those reports they're consistent in a reference to an area between half a hectare, 5,000 square metres, and 2 hectares. Ms. Wharf's correct that some of the growth projections that are in that report are done on a 5,000 and a 1 hectare, not a 2 hectare. But the key themes running through when I've referred back and had another look at those documents is that has it been a conscious decision through the growth management strategy to depart from the previous dispersed approach to the provision of rural residential growth throughout the rural area to taking an approach which I believe is more consistent with the Canterbury Regional Policy Statement to attach rural lifestyle development to existing urban areas, and to integrate with the existing infrastructure within those urban areas, and to provide for a minimum allotment size of 5,000 square metres where it can be serviced, and if it can't be serviced, for an area greater. In a lot of cases that being 2 hectares, but in some cases I think one of the specific control area developments provides for 10 hectare minimum within those areas. And aside from the rural lifestyle, there's also the future development areas which are identified, particularly north side of Timaru, and they provide another avenue for that type of more intensive, you'd say rural land use, but almost getting to the sort of densities that you'd expect of a residential or large lot residential. And a lot of plans would call a 5,000 square metre minimum, getting more into the realm of large lot residential as opposed to rural lifestyle.
Thank you. And my last question is following the evidence of Mr. Hole today. Did you hear anything that perhaps had a bearing on your assessment? He had presented the Waitaki plan example where there is an exemption in line with the relief sought. Have you had a look at that particular plan?
Yes, I did. Ultimately, and I think Mr. Hole acknowledged that a permitted activity approach to boundary adjustments is unusual. I would concur with that. The examples he showed are probably the exception to the rule. It's not the way that most district plans, particularly those more recently prepared under, well, I guess the West Coast joint plan being the exception, and that is more of a recent rule that has that. But it also is, it's not a blanket, it is subject to a number of caveats, restrictions, if you like. When I looked at that in terms of the proposed plan as notified, there's quite a few, it could be done, you'd have to change the framework of the plan structure a little bit to accommodate that. Ultimately, given that boundary adjustment is a form of subdivision, it's going to require preparation of a subdivision plan, approval of a survey plan under Section 223 of the Act, any conditions, not that there would be if it was permitted, but a Section 224 certificate and the like. I don't see that the requirement to obtain a consent is that onerous in the context of a boundary adjustment. Hence, I don't, in terms of a Section 32 analysis, in terms of efficiency and effectiveness, I don't see that it's that much more efficient.
Thank you very much.
At your paragraph 7.3.54 of your EIC, where you say the primary purpose of Esplanade Reserves is public access, not conservation, does that align with sub 05? It talks about conservation values.
Well, certainly conservation is part of it. I guess, yeah, whether or not, I guess the point I made there, it is debatable. The purpose of the RMA and the provision of Esplanade Reserves is primarily to preserve public access, and that may well have conservation benefits as well. But my reading of it is primarily the mechanism to get an Esplanade Reserve is to the ability to give public access to those riparian areas that otherwise wouldn't have.
So I've checked that and on the quality, MFE quality planning site. And just let me read out, it's not very long what it says. Esplanade Reserves and Esplanade Strips and access strips, collectively referred to as Esplanade areas in the snow, are statutory mechanisms to protect riparian and coastal margins. Riparian margins are strips of land identified along the edges of natural watercourses, including streams, lakes and wetlands. The protection of these margins helps to conserve environmental values and provides opportunities for public access and recreation. So to me, if I read that, I would think that one goes with the other and they're equally important.
Yeah, I don't disagree with that necessarily, so, yep.
So your comment in paragraph 7.3.54 is not quite right?
For sure, I'm happy to have that amended so that it's an equal conservation and access.
Okay, thank you. I have no further questions.
Thank you, Mr. Boyce. There's no further questions for the panel so far. We obviously will have your interim reply, so thank you.
Thank you.
Okay, next submitter is Inspire Residential Limited. I think are joining us by video link. Are they ready to go? We have a camera on.
Yep, we're ready to go, yep.
Great. We can't see you, but...
Oh, okay. Hang on. Hi.
Great. Welcome.
Thanks. Okay, are you waiting on me? So you want me to make my statement?
Sorry,
yeah,
my
okay.
apologies.
Sorry, I don't.
That's all right. We have a written submission, further submission from you.
Yep.
But yes, interested for you to speak to that submission.
Yep, sure.
Thank you.
Yep. Yeah, so I guess there had appeared to be a sort of an inclusion of my property by a submitter that they felt that it was a property of heritage significance in Timaru, and there sort of appeared to be a sort of hearing that was notified about it, and I wasn't included in that particular hearing, and I think that may have been in terms of serving the notice to the submitters or the people. It may have been in the local newspaper or something, but I never sort of got sent an email or received anything in the in the mail. So I just and I wouldn't normally bother. I'm sort of not particularly worried about things, but this is quite material, and it does really affect the property's nature of a property, its value, its purpose for being there. And so I was just a little bit taken by that I wasn't sort of included, and I guess I just wanted to, and I have sort of made that submission there that you've got there, that written one, just sort of not really about my concern about the court's process, about the notification. That things happen, and that's not the issue. It's mainly that I'd like my property not to be included in the heritage overlay, because really I just don't feel that it's of any sort of heritage significance. It may have had it's an old building, so it has history like all buildings do, but I don't believe that it's of any the significance to Timaru. It's down a driveway. It's got no street appeal really. It's been a block of flats for a very, very, very long time, and so I guess that's in summary. I just really don't want it to be included, and from what I've seen from sort of heritage assessments and planners at council, people are also of the opinion that it shouldn't be included in the heritage overlay. So that's I guess that's why I'm tuning in. I just wanted to sort of pass that on and say hi, and
Thank you for that. Look, I don't know if you caught any of the proceedings online yesterday, but we had a presentation from Mr. Templeton, who was the submitter who originally requested the property to be listed. And he's a local historian, and he gave us, did you see the presentation? Really interesting.
No, I didn't.
I think the slideshow should be available on the council's website, but it just has some really interesting social history around the site and its previous use that might be of interest to you. But you're quite right in terms of the council position as we understand it. Dr. McEwen, who is the heritage expert, undertook an evaluation using what is an generally accepted framework for doing that. In her opinion, it didn't meet the threshold for listing at this time. And we note your submission objecting to its listing. So thank you for tuning in. I'll just see if other panel members have any questions of you. Well, thank you very much, and thank you for taking the time.
No, absolutely. Great. Have a great afternoon. Bye. Bye.
Forest and Bird, I think we have Ms. Noyak joining us online as well. Welcome back.
Kia ora. Good afternoon. Are you all set for me to kick off? Excellent. Kia ora, my name is Nikki Snoig. I'm the Regional Conservation Manager for Forest and Bird for Canterbury and the West Coast. And Forest and Bird made a submission on the Energy and Infrastructure and Transport chapter, which I'm sure you've seen. I think we made a further submission as well. And I have some speaking notes that I'm just going to speak to the chapter, the definitions chapter, the objectives and the policies. It's as far as I've got going through them today. So I haven't sent that through to you yet, but I will I'll send the notes as soon as the hearing has finished today. I've finished today, if that's okay with you. Okay. So thanks again for the opportunity to present. Forest and Bird generally supports the Section 42A Officer's recommendations for the Energy, Infrastructure and Transport chapter. However, we do have some concerns with what is being proposed. We acknowledge that the points in our submission relating to the energy, infrastructure and transport activities in the coastal environment have not been addressed here and will likely be addressed later in the coastal environment chapter hearing. The main concern that we have with the officer's recommendations relate to the requirement for addressing adverse effects on Resource Management Act Section 6 matters of national importance, particularly Section 6A, the preservation of rivers, lakes and their margins, 6B, the protection of outstanding natural landscapes and features, and Section 6C, the protection of significant Indigenous vegetation and significant habitats of Indigenous fauna. This is of most concern in respect to adverse effects of new regionally significant infrastructure, as the provisions as drafted or as proposed by the Section 42A seem to extend to other types of infrastructure. With regard to the definition of regionally significant infrastructure, Forest and Bird supports the Section 42A Officer's recommendation for RSI and agree that the definition aligns with the Canterbury Regional Policy Statement definition, which purposefully differentiates between RSI and new or other infrastructure not listed as RSI. With regards to the EI chapter and the integration of the EI chapter with other chapters, some of Forest and Bird submission points were rejected by the Section 42A because they relate to the coastal environment. With the CE, the coastal environment, being part of the district-wide matters chapter, we'll cover these matters in the CE chapter hearing later on. However, we are concerned with the officer's recommendations to reject Forest and Bird submission point seeking to reference the CE chapter in the Energy and Infrastructure chapter ahead of the CE hearing. So Forest and Birds supports the Section 42A proposed addition of the words to the second to last paragraph in the introduction of the EI chapter that recognises that district-wide matters also apply to the EI chapter. Can you guys hear me all right? Yep, cool, excellent. There's a bit of feedback coming back for some reason. With regards to the EI Objective 1, the regionally significant infrastructure, Forest and Bird agrees with the Section 42A proposed amendment, and we support the inclusion of the words support emissions reduction to Clause 3. With regard to EI Objective 2, we support the addition of the words in the title. And Forest and Birds sought the deletion of EIO2 as it would not achieve Section 6 or give effect to the NZCPS. The amendments recommended by the officer, while an improvement, in our view, still fail to address Forest and Birds' concern. This is because the objective that adverse effects EIO2, Objective 2.1 are avoided is not achieved by the policy EIP2. This is a bit confusing, but hopefully it'll be clear as I read through the hearing notes. And where the exceptions apply in the objective, the effects management hierarchy in EIP 2.2 does not apply the avoidance requirements in Clause 310 of the National Policy Statement for Indigenous Biodiversity to other infrastructure, and for RSI does not include the requirement of the NPSIB 3111C that there are no practicable alternative locations. And so this is discussed in the wording again under EI Policy 2 below. So if EI Policy 2 can be amended to address our concerns, Forest and Bird would support the officer's amendments to Objective 2. Objective 3, Forest and Bird supports the deletion of Objective 3. However, we consider it is not appropriate to provide for other infrastructure on the same terms as for RSI, and that additional policy direction is required for other infrastructure to give effect to Clause 310.2 of the NPSIB and to achieve the Section 6 of the RMA Section 6 of the RMA matters, including in the coastal environment. With regard to Objectives 4 and 5, Forest and Bird supports the proposed amendments by the officer. And moving on to Policy 1, Forest and Bird supports the Section 42A officer's recommended wording, which aligns with the relief sought in our original submission. The recommended wording will give effect to the NPS for electricity transmission and the NPS for renewable energy generation, while reducing the potential for conflicts with the New Zealand Coastal Policy Statement, and also give effect to the RPS and achieve the Section 6 matters of the RMA. Regarding Clause 7D of Policy 1, Forest and Bird remains of the view that it would also be appropriate to support RSI in adopting new technologies that avoid adverse environmental effects. In our view, this would strengthen the policy and help to achieve the objectives of the plan. This additional wording would strengthen that policy, and we wonder why not include avoid adverse environmental effects as we put in our original submission. With regards to Policy 2, Forest and Bird sought a number of changes to EI Policy 2 without providing specific wording, or that might not be, ignore that, I don't think that's meant to be there. As discussed above in the key points, the Council has responsibility under Section 6 of the RMA to protect the values within areas identified in Policy 2.1a, and the avoidance of adverse effects is the most certain way of ensuring this. While we accept that there may be cases where it is still appropriate to provide for activities where adverse effects cannot be entirely avoided, there must be clear direction on when, for what, and where this may be acceptable. The NPSIB provides some direction with respect to adverse effects on Indigenous biodiversity, but it does not override the New Zealand Coastal Policy Statement in respect to the coastal environment. However, the policy includes seeking to avoid. Seeking to avoid is not the same as avoid, and in our view this is uncertain for achieving the objective 2. Nor do we think should functional or operational need be the deciding factor in areas where adverse effects, particularly for other infrastructure activities, which would otherwise need to be avoided in these areas. Having considered the Office's recommended amendments, we suggest the following changes to address Forest and Birds submission with respect to Section 6C of the RMA and the New Zealand Coastal Policy Statement, while recognising the need to give effect to the NPS for electricity transmission and for REG. So I've set out some words, or our planner has set out some words, proposed words for P2. Do you want me to read those out, or would you like just to see them in our notes when you have them? Read through them? Yep, sure. So say what's it? Sorry, I missed the last bit.
Yes, I didn't turn my mic on. Yes, please read them out, but we would like a copy in writing. Please.
Yep, sure. Yep, cool. I'll send that immediately after the hearing. So EIP2 for clause 1, we want to strike out seeking to and replace it with avoiding adverse effects on the identified values and qualities of outstanding natural landscapes, outstanding features, visual amenity landscapes, on the coastal environment, on significant natural areas, etc., etc. And for clause 3, we would add where there are no practical alternative locations and due to functional needs or operational needs, RSI and other infrastructure must be located in the environments identified in EIP 2.1A to ensure that, these are additional words that we would like to include, any new RSI and other infrastructure within the coastal environment avoids adverse effects where required in order to protect the special values and characteristics of those areas listed. And 2, any new other infrastructure avoids adverse effects on significant natural areas in accordance with 3.10.2 of the NPSIB. And where 1 and 2 are achieved or do not apply the following effects management hierarchy for any other adverse effects as already stated in that policy. We consider that the application of the effects management hierarchy in policy P2 is uncertain for achieving section 6A and B of the RMA, and that there should be further limits on any provisions for new RSI or other infrastructure to ensure that the values of those areas can be protected. Forest and Birds sought more clarity for Policy 2 in its original submission. Our submission was accepted in part by the Section 42A officer. Forest and Bird recommended that the policy be split to recognise the national grid and RSI and other infrastructure, and that appears to be what the officer has proposed. And they have included a new policy, EIPX, for managing adverse effects of the national grid. This separation of the policies for RSI and other infrastructure and the national grid is supported by Forest and Bird. However, as drafted, we think the policy still lacks clarity As drafted, Policy 2 seems to assume that RSI and other infrastructure can occur in insensitive environments, including in the CE and in significant natural areas, if they seek to avoid adverse effects, and in Clause 2. And by recognising that they have functional operational need, and in Clause 3 by applying the effects management hierarchy, including offsetting and compensation. The plan does not appear to include any limits for offsetting and compensation, and nothing seems to be off limit, including threatened species and habitat. And the policy seems to suggest that everything can be offset or compensated for. So we think the policy needs to include some limits to offsetting as set out in the CRPS and the National Policy Statement for Indigenous Biodiversity. With regard to Policy 3, Forest and Bird supports the Section 42A amendments to that policy, and also with Policy 4, we support that policy. And with regard to EIPX, managing adverse effects of the national grid, Forest and Bird supports the Section 42A officer's approach for a new policy, recognising the national grid is separate from the others. However, we do have some concerns with how this Policy X gives effect to the RMA 6A, particularly for lakes, rivers and their margins. And our planner has suggested that the proposes the amendments to Policy X are necessary, and recommends that the panel consider the recently agreed Marlborough Environment Plan Volume 1, Chapter 4, Sustainable Management of Natural and Physical Resources, Policy 4.2.3, when considering the environmental effects of national grid activities. And we think that this policy provides wording for the new proposed Policy X to better give effect to the national direction. That's all I have. My apologies, we didn't get time to go through the rules to make a comment on them. And at that point, I think I'll wrap it up. Thanks very much for the opportunity to present. I'll flick the notes through as soon as I can.
That's great, thank you. I'll just check whether there's any questions of clarification at this point. Otherwise, we can leave it and address it in a minute when we see the written statement.
Yeah, sure thing. Feel free to come back after you've read the notes if you have any questions. My contact details are there.
Yeah, I think it'll be more useful for us to see it in writing and compare it to the different versions of provisions that we've got in front of us and come back to you. Yep. That's great. Thank you for that constructive engagement with the rules and the plan. That's very helpful.
Excellent. Good luck. Thank you very much.
And I think that brings us to our last submitter today, Mr. Glass. Are you representing? Please come forward and take a seat. Thank you. Just before you begin, I just wanted to let you know that we have read the submission that you filed in writing in response to the plan, so you don't need to reread that to us. But as you may have gathered, if you've been listening in to some of the exchanges around the issues with SASMs, what we're particularly interested to understand is how they apply to your land, and any information you can give us about how you farm your property and your history with your property is very much welcome. But in particular, we're keen to hear from you about how you understand that the rules which are proposed might impact you in utilising your property. So we're in your hands. Thank you.
Hello everyone. I'm not Glass. Just on sites of significance to Maori, particularly on the wide Toaka lines that have been drawn over our property. I'll just go through what I've got here and then I'll maybe enlarge on it.
I do not support the drawing of the Waituoka lines on my land title at 264 Glenelly Road. These lines have been drawn and designate the gullies on the title. They are not a creek or spring and are only a floodplain when there's been significant rain. They do not sustain any fish life. Granting Mary the right to draw these lines on a freehold title with the power to veto future decisions on the whim of beliefs and values is totally wrong. When I tried to find out why these lines were drawn, that was the definition that I got, beliefs and values. I can understand if it is a true site of significance, married drawings, burial grounds. These can be defined and lodged. What Mary are trying to achieve by drawing these lines is seriously divisive. I am 1/16th Ngā Tahu myself, but I have serious concerns where this race card is going. If you're a New Zealand citizen, you should be a New Zealander, not split by race. We should look back with pride at our ancestors, but more importantly, look forward as united New Zealanders, making this a better place for our families and neighbours. I would like to amend the SASM Waitoka lines to the areas that can clearly be defined and stay away from the undefinable. Let's share our heritage, not divide it. Just in conjunction with the drawing of these lines, once something is put on a title and has a right to veto further decisions that can be made on that title, I don't know, what I envisaged that my family in the future might want to do there, but it can be quite a major, it's very easy to put stuff in place, but very hard to take it out. That's really, if you've got any questions.
Thank you, Mr. Glass. We are just being very careful about the way that we refer to these provisions. First of all, it's not on your title. It's a overlay in the district plan which applies to land, and there are many other different overlays in the district that apply to land, and rules in the plan that restrict how we can use our properties. So there's nothing novel in that. And the other thing, there's no right of veto either. This is a process, and it's been referred to variously in this process as a trigger, identifying an area which is of significance to Māori, which is a statutory requirement of this planning process. And then we need to consider, well, what does that mean in terms of regulating how you might use your land or how any other landowner might use their land? And we've got to go through an evaluation process and decide whether there needs to be a rule at all, or if there is to be a rule, what it is, and what information does the council need when it comes to deciding resource consent applications. This is not about taking land. This is not about putting a blight on your title or any other taking mechanisms. It's simply a process to enable an evaluation to be made about the potential impact of some activities you might wish to carry out on your land going forward. What would be really helpful for us to know, just to give us context, is what is your farming activity and how long have you had an association with your property in the district?
Just in clarification of what you're saying, it's the sites of significance is the thing that I've got a gripe with. We have not been very long at Glenelly Road, but I have been in the South Canterbury area off a farm at Albury in generations prior. We have moved to Timaru and bought a small subdivision block, or not, a lifestyle block there, and this title is on it. It was really the fact that that these lines are being drawn, or this overlay has been put over our property, but for what reason is very, very vague. And that is my concern, the vagueness of why these lines are drawn. Tell us exactly what the lines are drawn for, rather than beliefs and values. Give us something concrete, and I'm fully supportive. But because it is such a vague reason for the lines being drawn is where my concern comes. And just moving forward, the implications that could possibly have.
And that makes that clear, and I do understand what you're saying. We've had a number of submitters who are wanting to have some greater understanding and information around what the significance is of these areas that have been applied in the plan, and that's something that the panel will be thinking very carefully about. And when we look back again at the information that's been provided in this process, there'll be some questions in our mind about that too. So thank you for that. I'll see if the other panel members have any questions for you.
Good afternoon, Mr Glass. I just wanted to let you know that Kāti Huirapa did not ask to have these overlays. This is a national directive, and as our chair has said, it's come down from government and councils must implement it. Just to let you know that.
Thank you very much.
All right.
Kia ora. I have just a couple of questions. My first is the SESM that applies on your property is indicated as SESM 12, which is Tipua Saltwater Creek. And I wanted to know, does that exist on your property? Does it physically exist there?
There is only a floodplain. There's no actual creek as such, no.
And if it went into flood, would the creek then have water in it? Is that what will physically...
In significant rain, it will flow, but you've got to have significant rain. Otherwise, and if the rain ceases within, it might flow for a week, and then it'll be stopped for, yeah.
Okay, so it's currently a dry water creek.
It's really just a floodplain from, it is basically just a gully that when there is significant rain, the water will, it's got to go somewhere, so it runs down, a gully.
And so looking through the rules in this district plan that then would apply to that SESM number 12, I've just gone through and I can see there's no restrictions on buildings due to SESM or temporary events due to SESMs. Yes, well, as the rule's been written. So then it comes down to, and neither does it relate to the woodlots and plantation forestry. So the only two rules that I can see that would impact so far would be, based on what the reporting officer has recommended, would be the mining and quarrying and potentially some changes in earthworks, because earthworks would already be controlled under the earthworks chapter. So I wanted to know just those two activities, earthworks and mining and quarrying, what type of activity do you carry out on your property for those?
Nothing, no. There's no, it's just a lifestyle block at this stage with beef and sheep on it. And there's no quarrying, no, nothing.
Okay, thank you.
It was just the future restrictions that could possibly have, that was the...
Sure.
Mr Glass, when in the future, and I sympathise with your concerns, and in the future, if anything was to be triggered, for example, you wanted to subdivide or any of those would all go through a resource consent process. So I think a commissioner has asked if quarrying or mining or forestry or significant earthworks would ever occur on your lifestyle block. And I know where you live on Glenetti Road from the mapping, and yeah, I think it's the future that is of concern to like yourself.
There is possibility that you know, that
Yes.
that could happen, yes.
Yeah, but the thing is that would trigger a resource consent anyway. So then it would be thoroughly reviewed at that time.
Yeah.
Yeah.
Thank you very much.
Thank you, and thank you for taking the time to come and speak to us.
No, thank you.
Right, I think that's the end of all of the submissions today. Ms. Vila, did you have anything you wanted to raise? Sure. Yeah, and the panel will take stock of matters too and start to contribute to a bit of a to-do list as well. Yeah, thank you.